Good afternoon, good afternoon, good afternoon, and depending on where you're watching, good evening, good morning, all the things. It's Tuesday, it's August 12th, 2025. We have some court today. We have all of the things going on, but if you were with us last week we covered a court hearing in Massachusetts. Same old courtroom, different judge, different case, mostly different lawyers, except for Attorney Lally, who had been on the stand a few weeks before that in the Myles King case. So there's a discovery hearing set for today. There is a kerfuffling going on with the pool camera, so we were working on that. We are not the pool camera, but trying to find all of the things. So today might be a little bit clunky because we've got part of a hearing and then we are waiting for the other part of the hearing, so we will see. We also have some other documents to cover in the Karen Reed case, and then tomorrow there is more court that we are going to be covering a bit on a delay. So law nerds, it's good to see you. I'm still not done with coffee. I have hydration. I am so discombobulated. It has been a crazy last couple of weeks. It's been a crazy weekend. Replay crew, everything's going to be time-stamped below for a smoother experience. Streaming is dynamic. We're just going to do all the things. It'll be fine. And then anything we don't hit today when it's live, we'll just pick it up later in the week. So that's what we're going to be doing. So today, my anticipation is that there will be some discussion about discovery in the King case. There is also a hearing on the Walsh case. I'm not going to cover that today. We might cover it a different day, but we are going to talk all about the discovery issues that are going on in the Myles King case, which, though I am not covering that case per se, we have so much to talk about with Attorney Adam Lally, who had been the prosecutor on the Karen Reed case before they brought in Hank Brennan, with Trooper Proctor, with what seemed to be systemic and ongoing discovery issues in Massachusetts, especially and particularly with the Norfolk County District Attorney's Office. So though we are not covering per se the King case, it is a accusation of a homicide, so it's a murder case. Myles King has been let out of jail on a significantly low bail and house arrest because of the discovery issues. So someone who was no bail has already been released because of the discovery issues delaying trial. This has been delayed now for years. It seems that there are still things from the very beginning of the case that the defense does not even have. So we are seeing these discovery issues pop up again and again and again. And it's wild. The stuff that was being complained of by the defense in the Karen Reed case is going on in these cases too. And these discovery issues are just a disaster and shouldn't be happening. So I am keeping an eye on the discovery because I'm A, curious what the courts are going to do, and B, somewhat stunned that this is as bad as it is. It's just turn over the discovery. It's really not that confusing. So we're going to go to court for the best that we can. We also have the entirety of the disciplinary action with Trooper Proctor. So if we need to go over that, we will. It's just going to be so fantastic. So I am very excited to see what's going on in court. And of course, when we get to Q&A, we'll talk a little bit about DCI. Yeah, we will. We'll talk a little bit about DCI. Look, I will say this in sub and substance. The way I screamed for the Boston Crusaders to win their first DCI World Championship titles, it's been 85 years. Like, it's literally Titanic meme. Literally, it's been 85 years. And I was so excited for them. It was their year. Boom is a great show. They are a great core. And it was wonderful to see. And how excited people were was just it was just incredible to see the excitement of literally everyone. All the cores, probably not the blue coats, but all of the other cores, everyone was so excited. And I just screamed and screamed and screamed. Look, Boston, celebrate your core. It's so exciting. So, Massachusetts, you got a great drum and bugle corps there. And, what a huge win for them. So I'm incredibly excited. So We'll be talking about Massachusetts in other ways that are not so exciting, but in all the DCI ways, it's very exciting. And I know Flow Marching recorded a special victory run. I've already seen everybody that was doing their victory run with their GoPros and stuff around the interwebs, and that's really fun to see too. So with that, that was my alert, not yours. With that, we are going to, we're going to go to intro. We're going to go to court. Let me know where you're coming in from, what you're drinking. I still have coffee. I still have water. We have a cup restock. We'll talk about it in a little bit because we have a version of this cup that is restocked for you. So we're going to talk about that in a bit. All right. Are we ready? Let's roll the intro. And members, thank you to all of you who have been able to help me tech test. We are so close and I am so excited. So I'm ready. You're ready. We're ready. I'm so excited. Let's roll the intro and then, let's go to court for as much court as we have. We've back to Logan. We're shipping up to Boston. Again. Hey there. I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time, so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. All right. So today we have been grabbing the NBC 10 feed out of, courtroom 2 or whatever it is, the same courtroom that the Karen Reed trial was in, keeping an eye on this hearing. There are a number of other evidentiary hearings set today. No one's going to take the stand today. This is to figure out what the judge asked last time was for the attorneys, particularly the defense, to narrow down what discovery they were saying was prejudicial to their client. Not just what was late. The court's like, we know it's late. We've already remedied as best we can the late, which is letting the defendant out of custody, delaying the trial so the defense has more time. The court put those remedies into place that the defense was asking for. Now it's trying to figure out what may or may not be Brady and what is prejudicial to the defense. So taking all of the things that are late and then narrowing that field down. And that's what the court asked for last hearing, put it over to today. Remember, before that, we saw Lally on the stand. Lally and Proctor aren't going to be back on the stand until this is narrowed down. So it's kind of cart before the horse, because I'm sure anyone would want to ask Lally a million questions. I have questions. You have questions. We all have a million questions. But the court is trying to narrow it down to particular items of evidence that may, also may not, but may cause the case to get dismissed. And the court wants to narrow that focus to things that are prejudicial and irremediable, which is the language used in the law in Massachusetts. So you have to have those two things together, and the court wants to focus on those, because if you're just focusing on what's late, like literally everything, I mean, not literally, there's probably a few things that were turned over on time, a handful of police reports and whatnot, but that's what the court is doing. So we're going to peek in on what's going on in court. Then we're going to see if court comes back, because at one point this feed cut and court comes back for the rest of the hearing because a different hearing is going on in that courtroom right now. And we might pop back to that a different day. But for now, I am waiting for the pool camera to pool camera again. So we'll timestamp everything down below, and court's dynamic, streaming's dynamic, the days are dynamic, and we're just going to go to court real quick. So this is the attorneys in court waiting to start court. Yay, court. So the defense attorney in the case that we are focused on is sitting at counsel table going through pages. Blonde woman with shorter hair. So we've got all the attorneys in court. There are multiple hearings in court. That is incredibly common. I'm going to put us up at 1.25 real quick, just so we have it. And we've got just court background noise, which is not.
So is this saying that I can't provide copies, but I can discuss it with my client? Yes, that's not clear. Just want to make sure we all are on the same page. What it says is, defendant shall not dictate or provide the text messages to any other person, including the non-client.
I'm going to slow that back down, because even though they're not on the record, they're near the camera and they are talking about text messages, which I presume are Trooper Proctor's text messages, which are all being turned over. Well, mostly being turned over. Some will regard other things and not be turned over, but it's a protective order on those, which means they can't be turned over everywhere, but they can be shared with the client. They can't be shared with the media, right? But they can be shared with a defense attorney's client. So let's hear that again as they come close to the mic. Look, if court's got nothing but hot mic moments, we'll just talk about it. The jacket's really cute. Is it cold in that courtroom? It always seems like it's hot in that courtroom.
So is this saying that I can't provide copies, but I can discuss it with my client? Yes, because that's not clear. I just want to make sure we all are on the same page. Because what it says is, defendant shall not duplicate or provide the text messages to any other person, including the non-resident defendant.
By provide, I mean
Provide a copy.
So the clients can't be given a copy of the text, but they can read the texts. They can discuss the texts. Okay, that's fine.
arguably your client can take a photograph of them and then.
Right, no, all of my protected stuff is in a red file in my office.
The clerk was asking somebody to go look for an attorney, and then those near the hot mics are talking about, look, all the stuff that's protected is taken care of. We don't want anyone sharing it either.
Nobody gets access to it. Nobody copies it by accident. Right. So it can't get copied, it can't get disseminated, it can't get sent out.
Yeah, they're talking about the protective order over Proctor's texts.
Now I got it. Say how
Fair.
Oh, that's what Tracy and Ann sent.
This is the exact same one? Yeah.
I mean, fair. So those are going to be regarding Proctor's text that they're talking about off the record. We've got more attorneys.
I thought you weren't coming.
And the judge. No, more attorneys. Somebody said hi, judge. I don't see the judge on the bench yet. So we are waiting for
John Johnson.
the court to come out on the bench.
Okay, so then I just wanted to tell, well, is anybody other lawyer here?
I don't-
I don't know. So we have filed our motion to intervene.
With Judge Casper. Any response from her?
Well, it's been like, 20 minutes.
Oh, okay. All right. Because I called this morning and I was trying to figure out if you had filed that. Not you, I called the court.
Yeah.
Tried to figure out if it.
This is the most like court thing ever where they're just scheduling, just chit-chatting and scheduling.
Are they going to tell you anything? I don't know. Well, we filed.
So I'm going to wait for the judge to come on the bench. They're just back and forth about the emails and the text messages and how the text messages should be handled. And we've got attorneys coming into court. It looks like everybody's coming back into court. All right. Again, logistics. Everybody's talking about court logistics. Okay. The attorneys are in court. It's weird that the camera angle is so different than the Reed case, just where it's placed. There's no jury there, which makes sense, but it's a strange thing to me to see how different it is. So. Your Honor, are we? No. They're all standing up, which means the judge is probably coming in. Will we get some hear-yees? That would be great. I would love some hear-yees.
Court's in session, please be seated.
Oh, thank you. Number 2, 19467 Powell versus Bernardo Vidal.
Remember last time the court said there are 4 cases that are all kind of dealing with the same discovery things? We have been focused on the King case. They are calling the docket on a different case. This is not the King case yet, but they are in court for numerous cases today to deal with discovery with, Attorney Lally, Trooper Proctor, Norfolk DA's office. And this is a hearing from today. We're a little delayed on real time, which gives us room for nonsense when it happens.
If I could keep it away from that, for a possible disposition.
I'm holding it for trial, so if there's a disposition, it's got to be before we got a final pretrial conference today, right? So that would be the time to resolve it.
Oh my God, the mic.
I have to talk to some of the
This is a different case. This is not the King case.
Understand that you're drawing a line in the sand, Brad, but
Courts call multiple calendars in a day.
The line in the sand that you drew with the motion to continue the main trial. But you folks proposed these.
well, at the time, I didn't know that the standing order with Judge O'Shea.
The court's like, you drew a line in the sand by setting trial. Let's go to trial. The defense is like, well, no plea deal yet. Different case, not the case we're looking at.
Okay?
I'm saying it on for 27.
Put it out for the 27th.
They're setting dates.
Okay.
The sound is terrible.
26th for a change of plea?
I'm starting a trial in one case in basketball.
Okay.
So I don't know when that's going to end. It might end a week from now. I don't know. That's what I'm saying. I'm just trying to do these things.
Well, I mean, I have flexibility to impanel on,
Really hard to hear the court. They're talking about when the attorney standing up is talking about being in trial and when he's going to be able to be back in court to deal with other things. That's what they're talking about now. The attorney on that case is saying, Your Honor, I've got a witness issue. So they're literally just dealing with logistics. We are waiting for them to call the case we are focused on, which is not this case. This is just normal courtroom business. Massachusetts. That's me. I don't know why I had my feet up, but I was going to close tabs to make sure I wasn't buffering, and then I was chatting. The court said he's not going to put over the trial date.
this is a 2019 case.
What? Did you hear what the court just said? The court said, I'm not going to kick off the trial date anymore. This is a 2019 case. What? It is 2025. Every case that comes up in this courtroom, I am completely baffled. Oh my God. The court said this is a 2019 case. It's 2025. And this case has been pending trial since oh my God.
All right?
Avoiding trial.
I'm sure.
I mean, I'll be here from trial.
All right.
And then I might have to have Mr. McDermott speak to Judge O'Shea.
I'll talk to O'Shea.
Yep.
I'll talk to him.
The defense attorney is saying, I've got another trial. So if you want to go talk to the judge in that trial, talk to the judge in that trial. And he's like, I'll go talk to the judge in this case. I'll go talk to the judge. I'll go talk to Judge O'Shea. Let's go. I'll go talk. Let's go. We'll go chat. I'll do that. We need this to go to trial.
And when I get off the bench, I'll give you a call.
Okay. Yeah, I think that's starting,
What's the case?
I believe it's a murder case. I believe it's the 2nd of September.
I'm sorry, it starts the 2nd of September?
Yeah, I'm pretty sure.
Oh, I thought you said you had a trial before.
No, that's the one down in basketball that's starting next week.
Okay?
And this is like a drug case that just gets stuck in between. So it's no fast thing.
Yeah, I'm not going to continue the trial. So, and there's no written motion to continue anyway. So, and the defendant will not be excused on that.
27.
27.
Good.
This is just them setting a trial date. The defense attorney is like, I got this trial. I got that trial. We got to put this one in between. We got this. We got that. We got all the things. Yeah. We got all of it.
Thank you. Number 8, Christopher Randall. Mr. Nelson, Mr. Army.
They're calling calendar. This is a different case. So they are calling the Randall case. Again, there are multiple cases on calendar. We are waiting for the King case. They are now calling the Randall case. We'll see.
Is Mr. Nelson in the other session? Coming up? I believe he's in lockup. Or it could be in lockup. Yes.
They're asking where the defendant is,
Lockup, but he also did it.
but they are asking where the defendant is.
Okay. You see it right there. You're right.
We might not even get to the King case before this feed ends.
Before the judge, Mr. Blair. He's before the judge, a second call.
All right, they put that on second call. We're doing a whole lot of just courtroom procedural at the moment. Second call means we're not ready yet. Can you come back to us? Like, come back and take my order later. We're not ready yet. Can you second call it, which means call it again?
Discovery issue case. Yes. Yeah.
There are two custody defendants that are here,
But I have them. I assume.
Mr. Johnson and Mrs. De Los Santos.
They are talking about different cases that are also having discovery issues with defendants in custody. It sounds like that's what they are going to call next, but we'll see.
Mr. King.
And they just called for Mr. King. So he's out of custody, so he will be present in court. The King case is the case we have been waiting for.
Defendants should be brought in before we identify ourselves.
One of the attorneys said, can we just call can we get the defendants up from custody before we start calling it? So let's continue. For those of you just tuning in, the King case is a murder case. It's an alleged shooting from 2021. Wow.
I think for these purposes also, can I have Mr. Tipton unmute himself? And I would, at some point, we might ask him to identify himself also. And Kelly Forges, I'm so sorry. And Kelly Forges.
So they do have attorneys on Zoom as well. With Love, Jada said, what was the 2019 case? I don't know. It was just one of the other docketed cases today. So that is the defense attorney with her defendant, King.
While we're waiting for them to be brought in, number 2, Orlando Montero, Mr. Reddington, and Mr. Clinton.
These are different cases that he's calling. This is all... We watch a lot of courtrooms that are dedicated to the one case they're calling in a day. This is incredibly common that there are multiple things happening, multiple attorneys waiting, and court rolling through multiple different things.
This is a Courtroom 1 case.
Oh, sorry.
Courtroom 1.
That's fine, yeah. Thanks for trying to get me in trouble.
And people are just wandering out, wandering in. The judge is on the bench and everybody's doing their work.
Sure. If someone speaks, they can identify themselves.
At least Jim the clerk's easy to hear. King is sitting behind his attorney. There are other attorneys coming in, and other clients coming in, other defendants coming in. So that's what we're doing. So there are multiple defendants coming in. All of these cases have discovery issues. A lot of the discovery issues are the same. So it is part of why these cases are all placed on the same day, because the discovery issues are similar. But not because the cases themselves are connected. This is one of the ADAs in court standing up, introducing herself. Hard to hear, but what she said is there are various ADAs on the various different cases because these are not a co-defendant case. It's not that all these defendants are connected to one case. They all have different cases, similar issues. So the judge is not consolidating them, but the things are put on the same day because you're all dealing with the same discovery issues and the same central involved party, former Trooper Michael Proctor, Attorney Lally in the Norfolk DA's office.
Okay, so just for the record, we have this case is Powell versus Myles King, 21-320. We have Bianca Chanchillo, which is 22-265. Giovanni De Los Santos, 22-267. And Mr. De Los Santos is here.
He is.
Right here, Judge, in the white shirt.
We have Sean Johnson, 22-268. Mr. Johnson is present.
He is a purple shirt.
Okay, we have Brian Walsh, which is 23 CR 91. And I think those are all the cases that we currently have on our docket for today.
And it's not clear to me if Mr. Walsh is present on Zoom or if his presence is today.
First of all, the sheriff
5 cases dealing with the same discovery issues. The Walsh case, which a lot of you have heard of, Johnson, Del Santos, Chinchero, and King. Those are the cases that are on calendar and present. Defendant Walsh is there via Zoom. So let us continue.
office is there.
Or let us not continue because the feed just cut. I thought we were going to get a little farther before the feed cut, but we did not. So we are going to wait and see if the rest of this feed comes up. If it does not, then we will grab it elsewhere. But those are numerous cases with the same issues. I can't believe it cut right as they were calling the case. That doesn't make any sense. Let me go back to Boston 10. Otherwise, we might have to just grab one of the Zoom feeds, but it looked like those also cut. It's so wild that I don't know if they had stream issues or what, but it was wild because there is wild. Chronic Truck, thank you. How can we deal with all these? Person who know all the things isn't even there. The court is dealing with discovery issues. So the court has to deal with discovery issues. And there was a pool camera in there, and the pool camera in there just absolutely cut. So it is, I'm actually really surprised that it did not come back up. But we can go grab one of the Zoom feeds and see how that goes. But that one ended up, it looks like cutting too, but we will see, unless the hearing is over, which it might be. So let's go grab one of the, that was loud. Let's go grab one of the Zoom feeds. I can't believe that the pool camera just disappeared. It's so incredibly frustrating. But we're going to get a different view of that from one of the Zoom feeds. And if that's what we have to do, then that's what we have to do because, well, we want to hear what happens, don't we? So let me see what else is live. And I hope that people have permission to stream the Zoom feed because otherwise that's going to cause problems too. But I'm assuming people have permission if they are streaming the Zoom feed. So let's go ahead and grab it. I mean, there was obviously a pool camera there today, so that would have been given permission for, and we will see. So let me go grab it. I can't believe the pool feed just yeeted itself. Let me try to find where we were in time for that pool feed, but it is wild to me that the pool feed just yeeted itself. Emily, stop complaining about the pool feed. We will, let's see if I can make this a little bit bigger. So I will try to grab the Zoom feed on Restream real quick, but it's got tickers, which you know how I feel. You know how I feel, but we will do our best. So let's see how that sounds, and we'll go from there. because I am stunned that there's no pool feed. Truly. But it is what it is. And the pool has not come back up. And that's easier than waiting for another feed. Let me try to get ourselves into the right time and place in this feed real quick. So let's see. I think this gets us to the right place on that. Let's see if we can hear it. Nope. I do not have any audio on this. Let's see. Let's see if we get audio on this. Nope. Absolutely not. We got our audio gained all the way up. We've got this audio gained all the way up, and there is no audio.
And analyze.
There's finally audio. I don't know where the audio comes back. I don't know where the audio comes back in at. RIP to everyone's ears. I'm so sorry. All right. I don't know where that cut back in, but give me one sec. Streaming is dynamic. Apologies, chat. Apologies. So let me see if I can grab that. Thank you, Miguelina. I don't know either. Because the YouTube feed cut, that is so incredibly strange. Sorry, chat, just give me a moment. I didn't even anticipate the court feed not coming back at all. So give me one sec. And we will pull that up. Miguelina, I will go back and try to find the spot where the audio clips back and see what we can do about that.
You didn't.
There we go. We're going to get some of this hearing, but not all of it, and it's not going to be smooth. But again, we will do what we can do because audio is important. And even if it's all we have, audio is important. So let's try that real quick and see if that works. The pool feed was wild. All right, that should work. Let me just reset it. And I might just reset this as a side-by-side chat. Give me one sec. Thank you, everybody. I know I said today was going to be clunky, and we're gonna prove that to be true. We're gonna absolutely prove that to be true as I'm working with my my setup the best that I can. That's not what I wanted to do. So give me one sec to change this setup and add the screen back to it, because this will be so much easier once we have our own software, which is coming. We're almost done, and I'm very, very, very excited about it. So let's see. I need a different layout, and it is fighting with me. Let's get rid of that and that, and let's do this. We're going to crop it just a little bit so that it's easier for me, and give that a try. No, it won't do it. Why are you not playing nice? Come on, feed. All right. Let's do the best we can with audio and see how it goes. We are grabbing this from the Young Jerks who are streaming it. I'm assuming they have permission to stream it, because if they don't, it will probably get yeeted off of the interwebs
Today.
So optimistically, wild.
Which is contingent on what Judge Casper might do.
We've also missed some because there was audio. We will pick it up later, or we will pick it up tomorrow. I just want to hear what they're going to do with the discovery.
There are a lot of things I could do, but it would be very if this, then that, which is problematic for me in fashioning a suitable remedy.
I understand that. I do think that, and this court is aware that there are, that the federal law is significant in this regard.
But so is the state law.
I do not have any closed captioning on this, which is also making me crazy. Chat, I'm going to put up a poll because I can grab this later and put closed captioning on it. And we can go over former Trooper Proctor's disciplinary report and capture this afterwards and grab closed caption on it after it's done and cover those things. Or I can also summarize it, or we can just run with it. So I'm going to put up a poll and see what you guys want to do, because chat gets to pick. So let's start a poll. Let's start a poll because we can do either. Let's see. All right, I'm going to put up either way, we're going to end up covering it. It's just a matter of when. Let's see. All right. Let me get the poll up. I'm going to let you guys answer because Lord, just a mess. A lot of you are like, just run with it, which we can do too. It's either way. I'm going to let you guys pick. Chat gets to pick. Chat gets to choose their own adventure today. So choose your own adventure. We'll go with what chat decides and roll from there. So I'm going to pull up a few super chats while you guys are voting. Let's see. Some of you are saying Proctor. Some of you are saying run with the feed. It's close, man. Get your vote in if you feel strongly one way or the other. Let's pull up a few super chats while we do that. Brian, good to see you. Brian said, Emily, before we get into all this court stuff, I have to ask your opinion on BAC over Blue. First of all, I do not know why the Boston Crusaders are called BAC, but I feel like if there was ever an acronym to apply to Boston, BAC works for me because it's hilarious. I'm excited for Boston. I really am. Again, it's been 85 years. That's not to say that the Bluecoats aren't a great corps. They are. The world-class corps are great corps. Boston had a great show. I'm not going to get into the history of the up and down and the feelings about the judging and all of the nonsense that can be. Boston has a great show. They had a great year. That Mellow feature was just sick. Their guard had some incredibly challenging aspects to their show, and it's just a great, great show. It was their year, and it was time, and it's been time. Also, in all of Lucas Oil, when they announced the scores for the Bluecoats, you know what? I didn't hear anybody screaming. Blue. There was no blue. There was no bluing. Everybody was screaming because they were excited for Boston. Sometimes it's their year. So I'm excited. I've been rooting for Boston this year. Look, I knew Cavaliers weren't going to win. They had a great show. I loved their show. I have a whole bunch of opinions about finals, but I loved their show. They're proud of the show they put on the field. I loved watching it every time I saw it. My kid has been in shows that have not been my favorite, and you watch it and you're like, yay, my kid. And then you're like, when the season's over, I never have to think about this show again. That's going to be great. But that was not Shapeshift. I loved watching Shapeshift. It was a joy of a show for me. And people in the stands, everyone I spoke to, people were like, that's a really fun show. It's a good show. I like the music. I like the props. I like the guard. I like how they shapeshift. I like their formations. but they're not going to be top 5 this year after last year. We know this. So Boston, I was just hollering every single time I got to see their show. Boston area Crusaders, blood alcohol content. BAC. BAC. But we can talk about core more for sure. Right? You like that? You see what I did there? Tiffany, it's so good to see you. Tiffany said, Emily, thank you for being so amazing when my family harassed you at DCI. At 40, I did not think my parents could still embarrass me. Your family was absolutely lovely, Tiffany. No embarrassment needed. Also, isn't it our job as parents to embarrass? And then it's our job as kids to still be embarrassed. Your family was lovely. And it was lovely to meet them. And it was lovely. It was an emotional roller coaster of a weekend, but it was really fun to talk about DCI plus Law Nerd World. It was very fun, but it's an emotional roller coaster for everybody. Is BAC sponsored by MSP? I mean, right? So I appreciate the Boston area Crusaders, but look, man, their acronym is BAC. It's Boston. What is happening? I can't. Oh, you guys, we are 52:48 for Run with the Feed. I'm going to give it one more minute because we're at not even 3,000 votes and there's almost 10,000 of y'all here. Some of you are like, I don't care. Whatever we do is fine. Like whatever we do is good. I'm going to give you another minute. Miss Behaven, are we going over Morrissey's emails? Not today. I have not had a chance to grab them all. We might go over some of the headlines depending on how long court takes or how much court we have or whatever. But I don't have the entirety of the email dump. If anyone wants to email me, actually, if you're in the Law Nerd Lounge and you want to just put a link, if you have a link to the email dump, I've seen a lot of coverage of it. I have not seen anyone release all the emails. They might not have, but it's going to take a minute. It's just going to take a minute. But you guys are like, run with it. All right. We run with it then. Then we run with it. Minions, tonight we steal the moon. We'll just run with it. We'll just run with it. All right. But also, y'all, I just got home. So like my entire soul is exhausted and my kids start school. So I haven't gone and looked for the email dump. I saw that it happened. I was like, we'll get there. We'll get there. We'll get there. All right. You guys voted for court. Let's go back to court. Let's go. I appreciate it. You voted. To court we go. So let's do it. Thank you for the vote, Law Nerds. We let you guys decide, and there we go. Let us get back to it. I appreciate the poll. For all of you, like, are we getting back to it? No, we had to let the poll run. We had to give everybody time to vote for a minute. All right. Thank you for the poll. Let's go. Let's go back to court.
Law, and regardless of what the federal law says or doesn't say, you've had custody and possession of these records for more than a year. And this is, we've talked about this already. It's at the very end of the time that this is all coming to a head. And leaving aside the question about whether you control the records, which is the operative language in a lot of the filings, you clearly have possession and custody, and that's what the feds are worried about. Rule 14 says what it says, and our constitutional interpretive case law says what it says in terms of the obligation on prosecutors to review and disclose that type of information. So
right.
The court has significant remedies available to it, and that don't involve ordering you to do something in violation of the federal law, okay? But there would be consequences on you and your prosecution of these cases if you did not comply with your state constitutional requirements or your Rule 14 requirements with respect to the material that's in your possession and custody.
But that's why we're acting in the manner in which we're acting, Your Honor. And I want to be clear.
We can't see the prosecutor because of all of the Zoom, so we can't see the prosecutor.
as the court now is aware,
Because the prosecutor's in
the order
court.
itself prohibited this discussion prior to only recently.
I don't know that. You've given me a December 2024 order. I don't know what was in place in February. I don't know what I
That's
think there was a
Defendant Brian
date
Walsh.
between.
That's Defendant Brian Walsh. There are 5 different cases that the court's talking about with the prosecution not turning over discovery and saying you have an obligation to do so.
February and December where there was another order. I haven't seen those orders.
So I can
I mean, I don't know why you can't give me a copy of what you filed with Judge Casper or give to defense counsel, to be honest. The fact that it's a sealed proceeding, it doesn't mean that you have to file everything, you have to keep everything that you file in that proceeding under seal.
I'm relying on the advice of our counsel, and we have repeatedly asked for those previous orders. We have been told that those previous orders substantively are identical to the most recent order, that the reason there were multiple dates was if they provided for different people to sign the acknowledgement. That's all the information that I have.
Have defense counsel sought to subpoena the information from defense counsel in the Reed case? Because all of it was turned over to them.
I did speak to one of the.
Did you seek to subpoena defense counsel in the Reed case because they got all of it? Look, I understand defense counsel in the Reed case got the discovery, but they made a direct request to the feds, it seems, and so did the prosecution. But it's not up to the defense attorneys, my opinion, to turn over information to other defense attorneys, especially if there's a federal protective order. It's up to the prosecution. It's not up to the defense attorneys to fix this. It's not. That's a wild take, Your Honor. That's just not to be all Gen Z about it, but what? Just what?
Attorneys in the Reed case, Your Honor, asking for that information. It was that attorney's
It's not up to
position,
them.
that the document was under seal.
They're saying it's hard for me without closed captioning, but I'm backing up a second because the attorney is saying, we talked to them and they said it's under seal. Exactly. It is under seal.
The information from defense counsel in the Reed case, because all of it was turned over to them.
I did speak to one of the attorneys in the Reed case, Your Honor, asking for that information. It was that attorney's position that the document was under seal and that they couldn't give it up voluntarily. And they didn't know what.
This sounds like the defense attorney in the courtroom saying we spoke to the attorneys in the Reed case, and the attorneys in the Reed case, which was either Yannetti or Jackson, I would assume, said that information was under seal. Right. They can't just give it to another attorney. It's the obligation of the prosecution to turn over discovery. It's not the obligation of a defense attorney in a different case. And I have not worked as a defense attorney, but it seems to me that there could be ethical, maybe pauses to that's really outside of your job, because who knows if it could impact your defendant or your client. And your job is wild. What a wild request. Did you just ask Alan Jackson to give it to you? Emily Ippolito, I don't know why Brian Walsh's face is the largest one there. I thought we would have a pool feed, so I did not jump onto a Zoom to stream it. So we're stuck with what we're stuck with, or we wait. And the chat voted to not wait, so away we go. But that's a wild, wild, wild statement by the court.
They would do in return in response to a subpoena, but that's the information that I got from the judge.
Okay.
They don't think that they think that they're bound by the order. That
They are
signed.
bound.
Okay.
I agree with them.
Well, all right. Well,
I
if you
agree with
didn't
them.
subpoena them, it's not framed. It's not, the issue is not joined. The issue.
If we have a new hearing date, I'm happy to subpoena.
Mm-hmm.
But I don't have a subpoena for this court date because I thought that might be an abuse of the subpoena power because we weren't.
The defense attorney is telling the court, I did not subpoena Reed's defense attorneys because I thought it would be an abuse of the subpoena power of the court to subpoena a defense attorney in an unrelated case to ask them to turn over discovery that's impounded and under a federal protective order, Your Honor. Seems like it's a bit outside of what the defense is supposed to do. Can we focus back on why can't the prosecution just turn them over? Not how did Reed's attorney get them? The fuck? So mad. I'm so mad.
No. I agree with you, but we were not going to have evidence today.
No, you were never going to have
well,
evidence
let me hear
today.
from defense counsel as to what one or more think I should do.
So, Judge, on behalf of Mr. King and Mr. Johnson, I'm asking that you take action on our underlying motions that we filed for relief regarding the federal materials in possession of Commonwealth. I'm very concerned that we have 5 days. I was concerned when we were here last time that time the clock was ticking. I know the court was concerned. I know the Commonwealth was concerned. But the bottom line is that if this doesn't go the way the Commonwealth anticipates it will, then these documents are gone forever, and we'll have to file additional motions as to what the court can or should do under those circumstances. So we're asking the court to act on our motions in order the Commonwealth to review the evidence that they have in its custody. In the alternative, we're asking that if the Commonwealth declines to do that, or the court declines to enter such an order, I'd be asking the court to dismiss the cases against my client because he cannot get a fair trial without the opportunity to review and analyze the information that's been in possession of the Commonwealth since February of 2024.
Okay.
Judge, Attorney Krusk on behalf of Giovanni Della Santos.
Remember, there are multiple defense attorneys in multiple cases all arguing about the same discovery issues. So you're hearing different attorneys pipe in with what they're asking the court to do. And I think it's wise of the defense to keep the pressure on.
One suggestion is there, having practiced in federal court and still currently practicing in federal court, is there any reason that the government cannot make a call to Judge Casper's session clerk right now and find out whether or not it has been docketed and whether or not there's been a hearing order?
I'm sure it was filed by Pacer. I'm sure it was on Pacer and it's been docketed. There's a representation already that it's already been filed. But obviously I would like to know when Judge Casper is likely to see it and review it. She may be on a 2-week vacation hiking in Nepal. And so I don't know.
And that's sometime, I just know anecdotally and empirically, that's
They're talking about a different federal case because some of this is under the federal protective order to get it to the defense attorneys. And the court's like, I don't know what that judge is doing.
Information that the session clerk might be able to reveal that it's being reviewed. I understand the position that going forward, we don't need a court date every week, but certainly the posture right now, I think we need a weekly court date. So I think that
I agree with that. And I'm
the court's like, I agree with it. The defense is saying we need a weekly court date to figure out where the fuck this discovery is. I mean, I'm paraphrasing. But the defense attorneys have to keep the pressure on this and look, at this point, annoy the judge. We're coming back here every week, Your Honor, to be like, well, where is it? Okay, well, where is it? Okay, well, where is it? Sure.
I'm surprised the U.S. Attorney's Office didn't join in a 30-day extension. What's troubling to me is the U.S. Attorney's Office's position in the letter to Attorney Beatty, that they're not going to seek a further extension or further amendment of the protective order. So they seem to be saying we've done as much as we're going to do. Now, the information that Attorney Beatty is sharing with us now, or sharing with me now, maybe you folks knew before, that they've agreed to tolling. And again, we don't know whether Judge Casper is going to agree with that, but they've agreed with the idea of tolling, even if it's not an extension, just means we have that 5-day window that's preserved. And so that informs me about when I need a next hearing, unless we can get further confidence that we're going to have enough time to deal with this.
Well, I think we need a hearing on or before Monday. Just so clear on the record, on behalf of Mr. Della Santos, I'm joining the request that all Rule 14 discovery in the possession of the district attorney's office be turned over to Mr. De Los Santos, irrespective of any other order from any other court immediately.
All right. Any other counsel wish to be heard? Mr. Cataldo?
Yes, thank you. I think we need another date before the federal court, once they acted, Judge Casper acts. We need another date, a short date, and I think it goes without saying that we should order the district attorney's office to comply with Rule 14 and go through all of it and meet their obligations to us.
I don't need to order the district attorney's office to comply with Rule 14. They have that obligation.
Apparently you do. Apparently you do. They're asking the court to order the prosecution to turn over the discovery, and the court's like, I don't have to order it. They're obligated to do it, but they're not doing it. So maybe you should try ordering it.
Already. They already have the obligation under Giglio and Brady and related cases to produce information in their possession and custody, which are exculpatory.
They're complying with that.
Well, that's a question that I have. Okay, that's a question that I have in connection with
the defense said, well, Your Honor, they're not complying with that. And the court's like, well, that's a question that I have. How is this a question? How is it a question that they're not complying with it? It's pretty obvious when it comes to like search warrants that haven't been turned over, Your Honor. That's the point of being here.
Walsh filing with respect to the opposition to the motion to dismiss in the Walsh filing, and we'll get to that. But I don't need to enter that order because that is already their obligation.
Can I just make a couple additional points?
Yeah, I was thinking I might hear from Mr. Tipton before, but go ahead. I hear you, and then I'll hear from you.
I think Ms. Cusick is going to represent the Commonwealth on the Walsh case.
Okay.
She had filed the pleading that's more specific and responsive to the multiple pleadings in the Walsh case.
Okay.
So, I'll let her chime in at the end, but I do want to note that defense.
This sounds like the other DA that was in court. The two DAs that we saw on the pool camera sitting in court. This sounds like one of the other, the first DA in court saying, look, the other one's going to cover the Walsh case, but I'm just chiming in.
Counsel is orally moving to dismiss. The Commonwealth is not on any notice of that. So I would ask you not to take any action in terms of dismissal at this time. I also would note that no counsel has cited a case that outlines this particular procedural posture and how it interplays with Rule 14. And I appreciate that.
The attorney for the Commonwealth is arguing, look, this particular circumstance and what they're talking about right now is specifically discovery from the feds to the defense attorneys on the state case, which is different than the other discovery issues. They are talking right now specifically about federal discovery. She's like, there's no state case, there's no case law on point because this is such an unusual situation. But then the court should make an order to try to get it turned over. The problem is the state court judge doesn't have much control over what the federal attorneys do. And the prosecution in that narrow circumstance, the state prosecutors, the Commonwealth, does not have custody and control over the discovery that the feds have. They have custody and control over everything within state police, everything within the law enforcement team that works with with them. They have custody and control over everything with law enforcement that works with their DA's office in the state. That's one part that is a problem. The second part that is the problem is what the feds have that might be relevant for the defense attorneys. They don't have custody and control of that information that they're trying to get turned over. So this is where they're going back and forth. Like, what do we do about the federal discovery? And then what do we do about the state level discovery? The Proctor texts and stuff are part of the federal discovery. So there are two ongoing problems. And right now, the prosecution is talking about there's really no case law on point to this because this just doesn't happen. Right. It's a unique circumstance, but there's still discovery there.
The court is saying that you don't need to order us to comply with Rule 14. And I don't mean to be disingenuous when I say you don't. We take this seriously.
No, I understand that, and I'm not suggesting that otherwise. I'm really not suggesting
I know the
otherwise.
defense counsel isn't either.
Yep.
But this is a big deal.
Yep.
What is being contemplated here, and to throw these sorts of terms around these are important issues for the defendants. These are important issues to the Commonwealth, to the victims, and to our whole process. And this office is committed to and is continuing to work through these issues.
And I appreciate that, and I appreciate the way defense counsel's handled it, and that's the reason why I'm taking it in sort of an incremental way. I understand the sensitivity of it. At the same time, I'm trying to get us to a point where it is a non-issue, okay, where we can be satisfied that the documents, that we don't have to parse control versus custody versus possession, okay, and what that means under Rule 14 in this particular kind of a case. Because I'm not sure that there are cases that we'll find, certainly not in Massachusetts on this topic, and certainly not under Rule 14 as it's been recently amended. So I think we need to know what next steps Judge Casper takes, and we need to respond accordingly. And we'll give Judge Casper the opportunity to address these issues, understanding their sensitivity.
This is about the federal stuff. The judge is like, we have the separate and apart from the discovery not turned over by the Commonwealth. The federal side of it is a problem. But this judge can't control what the federal judge does and what gets turned over. So there are two ongoing problems here.
Can I just respond for sure? I know we talked about the Commonwealth talked about a response that they made in Walsh case. They haven't responded to either of the motions that we filed on behalf of Mr. King or Mr. Johnson. I don't have a copy of their response in Mr. Walsh's case. So to the extent that they've known about these motions since they were filed back on, July 18th,
That's fair.
2025, they've yet to respond and oppose it in any way. And now are we supposed to, the defendants in this case, are supposed to keep track of what's going on in Walsh to know the Commonwealth's position?
That's fair.
It's
We just jumped tracks into a different topic. So the defense attorney on the King case said, look, we're trying to keep up with what the Commonwealth is doing, but they haven't responded to our motion to dismiss. They've responded to the Walsh motion to dismiss. But we can't follow what's going on in the Walsh case for our case. They haven't responded to our case. So what are we supposed to do about this? There are 5 separate cases being heard right now, and the court is trying to parse how they're navigating forward. And all the different defense attorneys are saying, but in my case. And the Commonwealth did not respond in the King case and the Johnson case. And the defense attorney said, but Your Honor, WTF? My summary.
I understand that particular predicament, and I am happy to set a schedule for the Commonwealth to respond to your motions.
Yeah.
I don't think I'm prepared to address the Walsh motions just yet, but I want to hear from counsel on them. The issue that I raised, that I had a question on, I'll see counsel on the Walsh matter if they wish to address the court separately.
What a mess.
Mr. Tipton and Ms. Porges, I think you're up. I have a motion to dismiss or request for alternative relief. I'm inclined to go gently.
Yes. Nancy New 12 said it sounds like Rosemary Scapiccio, I hope I got that correct, is representing both King and Johnson. Yes, they are not co-defendants. Those are 2 separate cases. And yes, it sounds like she is the defense attorney on both of them, dealing with these discovery issues on 2 of the 5 cases that are having similar issues. The reason these cases are all having the same discovery issues is because there is a central theme here. Former Trooper Proctor, the federal discovery, the text messages, and the rest of it. That's why all of this is just a shit show. Because the defense attorneys are trying to do their job with like, hey, we saw what happened in the Reed case with what fucking former Trooper Proctor was saying. We need those texts in case anything impacts our case and our defendants to do our job. And the court's like, agree. However, I can't make the feds do shit. So we need the feds to give it to you. And so there's this push-pull trying to get the federal discovery that is completely separate from what hasn't or has late been turned over by the Commonwealth. Because the Commonwealth is obligated to turn over what's within their custody and control. Feds is not within their custody and control. You can't make the feds do anything the feds don't want to do. They're like a stubborn horse. There's literally nothing you can do, and they might just run you over or kick you. Like there's nothing you can do. And so the feds is part of the push-pull here. Which also makes me wonder how everything moved so smoothly for them in the Reed case. So, Candelou said, so the Commonwealth never had Proctor's texts. They did not extract Proctor's texts. That all came from the Fed side. So the Commonwealth does not have them within their custody and control. And if the Commonwealth had any of that, it's under seal in other cases, and you can't take sealed discovery in one case and disseminate it in another case. It's a violation of a court order. So it is a mess. And I don't know what's going to happen. And I don't think the judge does either. The judge is like, what? Huh? Because this is such a strange circumstance. But also, the Proctor fuckery is wild, right? So the federal side of this is a separate mess from the late discovery state side of it. They're talking about the federal side of it.
On this issue, and
so I'm going to just back up so we're not in the middle of the court sentence.
I'll see counsel on the Walsh matter if they wish to address the court separately.
The Walsh is a separate murder case.
Mr. Tipton and Ms. Porges, I think you're up. I have a motion to dismiss or request for alternative relief. I'm inclined to go gently on this issue and see what Judge Casper does in terms of either giving us additional time to consider this. Let me just ask again, Ms. Beatty, to say exactly the relief that was sought from Judge Casper. One, besides leave to intervene, what else did you ask for?
We asked for modification or a court order that would permit the Norfolk District Attorney's Office or outside counsel to review the materials. We also asked that we be permitted to retain the materials for a period such as 6 months so that defense attorneys could pursue their own avenues of obtaining the materials. And
I don't like this. I'm going to let her finish. I don't like what the Commonwealth is suggesting, because what the Commonwealth is suggesting is that the Commonwealth is asking the feds to let the Commonwealth review and then have custody of the federal data dump so that if other defense attorneys want it, the Commonwealth is in charge of disseminating it. I immediately hate that option. With everything else we've seen, I immediately hate that option. But they're saying, look, if the feds will let us have the discovery, we can disseminate it to the defense attorneys, and then we don't have to go through this every time. They need a discovery referee. They just need somebody. Why? No, you need a discovery referee. Just grab a commissioner, grab a retired judge, grab someone who's not connected to the DA's office, and have them be the discovery referee. It needs to be placed with a neutral third party that is the discovery referee. So whether that is, and I think a retired judge or commissioner is the right call for that. You need someone else. This does not need to go through the DA's office. Lyndon said we need an extra special master from yes, they do. They have to have someone who can handle disseminating that discovery. Someone please make that suggestion to the court. Please, just discovery referee, whatever they call them in Massachusetts. Someone needs to handle this. It's not the Commonwealth. KK, I said commissioner. I don't know well, in California, there are different levels of judges. So sometimes you have commissioners who sit in as judges, but also sometimes work as attorneys or judge pro tems. Like there's a lot of different options for that, but they are not always seated judges because you don't want someone else on the bench that's handling different cases to do it. There has to be someone else who can handle it, but not a commissioner in the sense of law enforcement, a commissioner in the sense of a judge-like person. There's got to be some type of discovery option that is not the Commonwealth being in charge of it. I hate that suggestion. 100%.
The Norfolk District Attorney's Office or outside counsel.
Outside counsel is the
to
better
review
option.
the materials. We also ask that we be permitted to retain the materials for a period such as 6 months so that defense attorneys could pursue their own avenues of obtaining the materials. And I just have 1 minute.
A third party is fine if that third party isn't like Brennan. They need someone not
We
connected
ask
to
that the
any
court
of this.
hold the destruction date in the protective order until after the issues, bless you, until after the issues raised in the motion are fully resolved. And as I said, we asked for oral argument. And I'm happy to ask our counsel whether or not we can share these pleadings, but I'm not prepared to share them at this time.
Okay.
At the appropriate time, Judge, I'd like to be heard briefly.
Yeah, hang on one
That's-
sec, Mr. Tipton.
Attorney Tipton. I don't mind the suggestion that a third party reviews it. Maggie said 6 months. Yes, they are asking 6 months to hold on to the discovery hold on for one more day. They're asking for 6 months to hold on to the discovery in case there are other cases where the defense attorneys need to request it. So they are asking for a period of time so it can resolve other cases so they don't have to keep doing this. That's why. But they're not saying it's going to take us 6 months to turn it over. That's not what they were saying.
So the second to last paragraph of the first Assistant U.S. Attorney's letter, dated August 5, says, in the United States' view, it would be inappropriate for the Norfolk County District Attorney's Office or Defense Counsel in the other matters to seek to intervene in the U.S. District Court matter and to move.
Listen to what the judge is saying. The judge is talking about what the Fed's position on this is.
So the
backed that
second
up.
to last paragraph of the first Assistant U.S. Attorney's letter, dated August 5, says, in the United States' view, it would be inappropriate for the Norfolk County District Attorney's Office or Defense Counsel in the other matters to seek to intervene in the U.S. District Court matter and to move to amend the protective order.
Yes.
That sounds like, other than the agreement with respect to tolling until Judge Casper can decide what she needs to decide, you're going to be faced with an opposition by the U.S. Attorney's Office to your motion.
What the U.S. Attorney's Office is saying is you can't modify the protective order. It's inappropriate for you to ask to modify the protective order, which means the U.S. Attorney's Office is essentially saying whatever we have under protective orders not being given to you. The protective order stands, and we're not disseminating it to you, whatever that may be, beyond Proctor's texts. So the U.S. Attorney's Office is like, nah. So no matter how much all the attorneys in the state case might want it, if the U.S. Attorney's Office says you're not going to get it, that's going to be a fight too. Now it's time for a breakdown. Never gonna get it, never gonna get it, never gonna get it, never gonna get it, never gonna get it. The U.S. Attorney's Office is straight up like, we're not giving it to you. Boy, oh boy, oh boy, oh boy. All right, let's continue on. I'm holding some questions for when we get to Q&A.
Intervene.
I agree with that assessment, Your Honor. And we took the steps that we took, notwithstanding the position of the U.S. Attorney's Office, and we reached the tolling agreement after this letter. So my point that I'm trying to make is, notwithstanding their substantive point, I do not think that they are trying to put this court or this district attorney's office in the position of violating either a state court order or a federal court order.
I'm moving me, so I'm not in the way of the judge.
Mr. Tipton.
Thank you, Your Honor. I mean, I heard you say you were...
Hang on 1 second. Can everybody hear Mr. Tipton? I have difficulty hearing him.
And y'all, I am borrowing this from the Young Jerks feed. I am moving me, so I am out of the way of the court. But that is where we are grabbing this from.
Well, hang on a second. Let's see if Mr. Tipton can adjust things on his end so that he can be heard better. Maybe you can increase the microphone or...
I just did. Can you hear me now?
Through a potato.
I'm practically yelling here, so...
An external webcam with a mic would serve a lot of attorneys well. You can just plug it in, or just email me. Email me what your computer is, and I will just send you a suggestion at this point. I'm here to help. Honestly, it's just purely selfish on my end, because if we're going to have to deal with Zoom hearings, I would like the audio to be better. Like I have suggestions.
I'll keep yelling.
No, I really can't hear you, Mr. Tipton. I'm sorry.
Maybe I should try to join using a different computer real quick, but I don't want to waste the court's time.
I can hear you just fine.
I'd rather hear you.
Judge, can I make a suggestion?
What's that?
Mr. Tipton calls my cell phone, I can put it on speaker and everybody can hear it.
How would that be?
Fine with me.
Okay, do you have, I don't need...
Thank you. Thank you, Rose. It sounded like Rosemary. Thank you, counsel.
To ask you specifically, do you have Miss Capiccio's cell phone number?
I don't think so.
Judge, I can share
just text each other.
it with Mr. Tipton right now.
All right, very good.
And I'll call in.
Or I can just call you right now.
You can call me.
Mr. Tipton, this is
Yeah, why can't the clerk put it on speaker?
This is Jim McDermott.
Thank you, Jim.
Go ahead, Jim, try that.
Sure.
Emily, why do lawyers lose their minds? It's this kind of stuff. It's this kind of stuff. It's this.
Well, here you are.
Hang on one second. Why don't you identify yourself for the record?
Yep. They've created themselves a loop of echo.
Larry Tipton for Miss Walsh.
You able to hear that? All right, Mr. Tipton, we'll hear you.
Fuck! Oh, y'all.
Just briefly, Judge. I think Liebman, whether it's the government opposes it, but Liebman seems to make it clear it's the Commonwealth's obligation to get materials from the federal government. There's no question when you read those two cases that is exactly what the SJC said way back in the 1980s. Secondly, the Commonwealth has failed to inform this court or any party.
Tipton is arguing on behalf of Walsh. It's all the same federal discovery dump that we're talking about. All of it's the same federal discovery. And Tipton is arguing that it is the obligation of the Commonwealth to get that discovery. I put myself up in the corner so I'm not blocking the faces down in the corner. To get that discovery and turn it over, and that case law says that. The Commonwealth has argued that case law doesn't say that, and that Rule 14 doesn't say that. Rule 14 in Massachusetts says anything under your custody and control. Things in possession of the feds are not under the custody and control of the state level prosecutor. So we are going to end up with a jurisdictional battle over the federal attorneys saying, good luck with that, we're not giving you anything. And the court perhaps saying to the Commonwealth, you have to turn this over. If they can't get it because of a federal court order, it might truly be outside of the ability of the Commonwealth to get. It's not like a search warrant that they haven't turned over that they need to get from state troopers that they can go get. This becomes a harder thing. And then the defense is in the position of saying, okay, well, if they can't turn it over to us, then what are we supposed to do? We know it exists. We know that it's out there, and we know that we don't have it. So now what? And then the court is going to end up in the position where the court has to decide if that this could be Brady, and if it's Brady that's not turned over, if it is irremediable and there is no remedy for it. And then what happens to the cases? So I'm holding on to a lot of your questions. Let's continue on.
What the exact basis is that they're relying on that says they can't review the documents in their possession and custody for Rule 14 information as defined by Rule 14. Now, I'll just say that when we were in Plymouth, they produced a December 2024 protective order. There was one they let us read it. We couldn't copy it. We had to hand it back. We did. There is a paragraph in it that seems to touch upon the issue at hand. But that paragraph, and I won't repeat it, but I think the government knows what paragraph it is, and it does not, in our opinion, prevent the government from reviewing the documents under Rule 14. It does have language that says you can't use the materials in any other case other than the Reed matter. But that's not what we're asking for. And for the government to continue to act
well, that's a problem.
A paragraph that says you can't use materials in another case means they can't review them under their obligations under Rule 14 is creative thinking, creative interpretation, and it's simply running away from their obligations. And
I don't know
finally,
if I
the
agree
only
with
other
that.
thing I had to say is what we said repeatedly, and it was based on what the government told us beginning on July 17th when this issue became known. And that is, why haven't they explained then why Attorney McLaughlin, Assistant District Attorney McLaughlin, did in fact conduct some type of review of these materials
Tell me more about that.
and gave certain information to either the prosecutor in their office and our defense counsel. Now, granted, I was never told they gave substantive information, but they apparently gave sufficient information to either their DA or the defense attorneys. And that is not addressed, once again, in the government's opposition today. And I have argued that since I was told that on July 17th. And I'll just add that when we were before Judge Ferner, and she read that, and I understand that she cannot rule on this issue because of a judicial conflict, but she confronted the Commonwealth about that very issue. And the government refused to answer. And so I asked this court, why can't the government simply explain that? Why they did it in one case, why they provided information to either their DA or defense attorney in an unrelated case, and why are they simply refusing to do so now based on language they have not produced that, in my opinion, would not justify anything, but they still not produced the specific language. So I understand the court's not going to rule on our motion to dismiss today, but the last thing I'd say is I hope that this court will schedule some type of status hearing no later than next Thursday or Friday. And if nothing else,
oh boy,
order the government to stay in touch with the federal authorities and have an immediate update about the status of their motion to intervene. And that's all I have right now, Judge.
All right, thank you.
oh boy.
Mr. Tipton, are you connected? You can hear us through the regular Zoom, is that right? I see you nodding your head. Okay, very good. If you want to make another point, jump in and we'll call you again. But I don't want to cut you off. I appreciate the positions. It does seem to me we need another hearing.
Yep. It's a meeting to talk about a meeting, to have another another meeting. What Attorney Tipton said is, look, if the Commonwealth is saying there's language, and the court quoted it, that there's language saying that the attorneys cannot use the information from the feds in any other case other than the Reed case. It was for the Reed case. It's under protective order. He's saying, okay, then how can Attorney McLaughlin review it and tell either another DA or another defense attorney in a different case? Because everybody's talking at this point. So how do they know if you can't review it and talk to anybody about it? Then why did you tell them? And why can't you tell us? And why haven't you told us why you told them and you can't tell us? So what is it? Either you can't review it or you can. And you did it over there. So why can't you do it over here? Where's the information? It's a fair point, because the attorney's saying we can't review it in any other case, we can't use it in any other case, is so different than we can't use it in any other case, but they know about it. And I don't think he's referring to the Reed attorneys, because the court would have shut that down and said, no, that's different. That's the Reed case. So Melodic in the chat said Schrodinger's discovery. 100%. 100%. Wild. And McLaughlin would have known what's in there because, yes, as many of you pointed out, McLaughlin was on the Reed case. So she would have had access to what's turned over in the Reed case. Mess. And the court said, yeah, we're going to need another hearing. Today was supposed to clear things up. Nothing is cleared up. There's just more arguing.
Nodding your head. Okay, very good.
Everybody's like,
if you
yeah.
want to make another point, jump in and we'll call you again. But I don't want to cut you off. I appreciate the positions. It does seem to me we need another hearing, informed to some extent by what Judge Casper does. Is there other counsel that wish to address the court? I do have one question for defense counsel in the Walsh case. Who's speaking on behalf of the Commonwealth in the Walsh case?
Your Honor, Tracy Cusick for the Commonwealth on the Walsh case.
All right. So I have your response to the motion.
I'm going to just let us roll through what the court is asking about in the Walsh case, because this is such a spider web of discovery wildness. I just want to hear what's happening, and then we'll just let it roll. We're already here.
A bit of housekeeping, if I could. That was a response to other motions. We received Mr. Tipton's motion to dismiss.
No, I'm sorry, I misspoke. This is a response to the motion for relief regarding federal materials. It's not a response to the motion to dismiss. But in your response to the motion for relief, you say the Norfolk District Attorney's Office is aware of its obligation.
We were going to wait on the Walsh case, but we might have to pull up the motion practice before we get much deeper into this, because there's so fucking much. So the defense has made a motion for relief regarding the federal materials, and the prosecution's responded to that. They're not even at the motion to dismiss. Ugh. Mess. It's a mess.
Under Rule 14, it's one of the last lines in your opposition, but you do not say whether you have or haven't complied with it. So I really don't know how you're interpreting Rule 14.
The court's like, can you answer, please?
How are you interpreting Rule 14?
Your Honor, we are interpreting Rule 14 as it is written, as we understand it to be written, that our obligation is to produce materials favorable to the defense, that our obligation is to, if we're aware of them, to inform the defense of those materials. We are aware of our obligations under Rule 14 in this matter, Your Honor.
But that doesn't really answer my question. We have unique circumstances here.
It's a fucking word salad is what it is. The court's saying, how are you interpreting Rule 14? Like, what do you think it means? So you can explain to me what you're doing. And they're saying, look, we have to inform the defense of any potentially exculpatory information. What's interesting is, what do you do if that information is not within your custody and control? How do you give it to the defense?
Is it your view that...
and the court's like, no, answer.
Even though these are nominally controlled by the feds, that you don't either possess them or have custody of them?
Your Honor, it is our view that doing what counsel is asking would be violating a federal protective order.
Reviewing the documents would violate a federal protective order?
In conjunction with a different case other than the Reed matter. In this case, we do have the unusual circumstance of someone assigned to the Reed matter is also assigned to this matter.
Right.
And
so your position...
So the Commonwealth's position is that they are... This is such an odd circumstance, but McLaughlin was assigned to the Reed case, is assigned to the Walsh case. Attorney McLaughlin knows what Attorney McLaughlin knows. Attorney McLaughlin has reviewed the federal materials in connection with the Reed case. But the federal protective order, the Commonwealth says that this can't be used outside the Reed case. But Attorney McLaughlin is taking, it seems, maybe a broad interpretation of, if you are aware of something, you have to tell the defense. It sounds like McLaughlin took that to mean, I need to let the defense know there are federal materials that exist, but I can't give them to you. So when Tipton is saying, how did they tell the defense about these materials? If it's McLaughlin, it's because she is aware of it and her obligation is to tell the defense if materials exist. So she told them, it sounds like she told the defense materials exist. And they're like, can we have them? And she's like, nope. You can't have them. I know they exist, so I have to tell you. But I do not have custody and control of them to give them to you because they're under a federal protective order, and I can't take them from that other case and give them to you. They are behind a wall of a federal protective order, and we can't give them to you. So that is how we end up in this very strange circumstance of McLaughlin being aware that materials exist, disclosing their existence, but not able to produce them. Which potentially puts the prosecution in a very bad spot, depending on what the court decides the remedy for that is. Because if McLaughlin is saying, I believe these materials are such that I have to make you aware of them, i.e., e.g. Brady, I have to make you aware of them because they might be Brady, it sets up a circumstance where McLaughlin did the right thing in saying, these might be Brady, I have to tell you they exist. And then the circumstance becomes irremediable because the feds won't turn them over. And then you might end up in a Brady violation that is technically not really the state's fault because it's not information that they can give or have for this circumstance. And then the court has to decide how you fix a Brady violation that can't be remedied in any way because the feds refuse to turn it over, which might hurt the Walsh case, which is wild. So I understand how we ended up literally between a rock and a hard place because McLaughlin did the right thing in this circumstance, it seems, saying, hey, this exists. So they can try to subpoena the feds, but they can't. A lot of you are saying, why not wall off McLaughlin? McLaughlin can't use the information in her case. She told the defense it existed because her obligation is to tell the defense if there is any potentially exculpatory materials. But if the defense can't get those materials, then it becomes an irremediable situation. That is quite a fucking pickle if they can't get the information from the feds. Huh. Lyndon said they can subpoena the feds if they enjoy being laughed at. It's a problem. And it's a problem that might hurt the state's case. But you can't have a defendant go to trial if there is potentially exculpatory information out there that's been disclosed but not turned over. It's a very difficult problem. And that's why the court is saying, we need to see what the federal court is going to do. And the Commonwealth is saying it would violate a federal protective order to give you this information. So we can't give you this information. But that might mean that their case has negative consequences. It's a very strange problem. Mel in the chat asked, could the defense FOIA Proctor's text? No, because they're under federal protective order, so you can't get them via FOIA. Huh. KK said McLaughlin can't use them in her case, but that's fine with the DA's office because everything in this case is discovery is bad for the prosecution, which is why they had to disclose it to the defense. And by disclosing it to the defense and not being able to turn it over, they put themselves in a position where their case might be at risk. Huh. This is a very difficult position for the Commonwealth. Because if the feds don't turn it over, I think it becomes an irremediable problem. Amy in the chat said, so this has never happened before. I've never seen anything like this. But generally, you do not have federal involvement until after state level stuff is done. Yikes. I don't have an answer for y'all. We're going to have to watch this play out, but it's not a good situation to be in if you're the Commonwealth.
Is even reviewing the documents.
So, all right, the court is restating the Commonwealth's position on this, and the Commonwealth's position is even reviewing the notes is a problem. Hold on, I'm going to save. You guys have great questions. I'm going to save them. We'll get to them. You guys have great questions.
Your Honor, it is our view that doing what counsel is asking would be violating.
So the judge restates this really well.
Order.
Reviewing the documents would violate a federal protective order?
In conjunction with a different case other than the Reed matter. In this case, we do have the unusual circumstance of someone assigned to the Reed matter.
Sorry, I needed to see how much Defendant Walsh was smiling. His face is going to make me take a personal interest in this case.
Of them.
Your Honor, it is our view that doing what counsel is asking would be violating a federal protective order.
Reviewing the documents would violate a federal protective order?
In conjunction with a different case other than the Reed matter. In this case, we do have the unusual circumstance of someone assigned to the Reed matter is also assigned to this matter. And
so your position is even reviewing the documents, reviewing the documents in this context is not required by Rule 14?
Your Honor, I believe reviewing the documents in this context would be a violation of a federal court.
That's not an answer.
Question.
That's not the answer. That's not the answer. The court asked, would reviewing the documents in this case be required by Rule 14? And they sidestepped and said reviewing it would violate the federal protective order. So what you're telling me is that you are obligated to review it under Rule 14 and you're not able to review it under Rule 14, which means you are not meeting your Rule 14 obligation. Is that what you're telling me? Yes.
The question is, does Rule 14 require you to review these documents?
I don't believe it does, Your Honor, in the current posture of this matter.
And is there anything you can cite to me that would support that position?
Right, the court's not buying it.
At this point, Your Honor, I would say there is currently a federal protective order. We are officers of the court. We are required to comply with that order. And I would suggest it is clear there's the balancing of that federal order
but you know
and
it
the Rule
exists.
14 requirements of which we are aware. In this case, I don't know if the court had a chance to read in detail the Commonwealth submission.
I did.
There have been prior TUI requests by both the government and by the defense in this matter. And again, the court has the response we received from that as well.
The TUI request, though, is a different question than whether the Constitution, Massachusetts Constitution, or the federal Constitution, or Rule 14 imposes on your office an obligation to review documents that you're in physical possession of. And I don't really, I know that, I don't want to say I don't care, but it's not particularly material to the question of what the Constitution requires of you.
That's court for I don't care. It's not particularly material. Court for I don't care. The judge is like, you know that these exist. And the court's taking the view that your office does have possession of these documents. The court's not taking the view that these are outside of the possession, which is a big deal for the defense. The court's not taking the position that you don't have them because of the federal protective order. The court's taking the opposite view and saying, we're not going to play word games. You have the documents in your possession because they were turned over in a different case. So the court's view is you have the documents. Under Rule 14, aren't you then obligated to review them? And then if you're obligated to review them, aren't you obligated to turn over anything potentially exculpatory or relevant to the defense? And the Commonwealth is saying, well, actually, Reviewing them would violate the federal protective order. Well, actually, we don't really have them because they're under protective order. And the court is like, but you physically have them. So you have to review them to turn over. And they're saying we can't review them because there's a federal protective order. And we can't violate that court order to meet the Rule 14 obligations. Well, then you can't meet your Rule 14 obligations, which is where the court's going. And if you can't meet your Rule 14 obligations, then what is the response for the case? It could be that the case gets dismissed, which is what the defense is asking for. That's the rock and the hard place that we're stuck between. Oh boy. Oh boy.
That a federal prosecutor somewhere said, I wouldn't give it to you independently.
I understand that, Your Honor. At this point, I don't believe we are required to review those materials in violation of the federal protective order. But certainly I would ask for some time to respond to the motion to dismiss that was filed this morning.
Yeah, sure.
And again, if something, for example, if something was in plain view, that might be something that would cause a person reviewing those materials in the Reed matter to bring that to the attention of the federal authorities or to others to say they're aware of information in the custody of third parties. Certainly nothing like that has occurred in this case. No one has indicated they're aware of any materials in the possession of third parties.
Okay. I'll give you an opportunity to address the motion to dismiss. We'll play this out a little longer and see what happens with the motion to intervene and motion for additional relief.
Well,
may issue
I got a bunch of
order
research
in
to do.
response to this argument, explaining why I'm doing what I'm doing.
Do it.
And I'll schedule a hearing for, I think, early next week. I could do the end of this week too. I'm here, but
wow.
I think the early next week is probably enough time.
I think the order expires on Monday.
The order expires on Monday. That's true. So maybe we should do it before the end of this week.
Could we do Thursday, Judge, potentially?
I have that flexibility, and we should know more from Judge Casper by then.
Thursday.
I could do Thursday morning if anyone could do Thursday morning.
This week?
Oh, Thursday afternoon, sorry. Thursday afternoon.
I guess we're covering this on Thursday.
I can stand it for you.
I'll just reach out to the court and ask for the Zoom link and permission to stream it, and we'll just do it ourselves.
Okay.
Since apparently there's not going to be a pool feed.
Yeah, Thursday afternoon at 2 I could do if I'm just trying to give us some time.
Wow.
Yeah. I'm flexible given what everybody else's schedule is.
What
I think
a
3
mess.
days is probably enough time to get a read, or 2 days. It's only 2 days, but get a read from the federal court as to when they're likely to address the issue.
Not do Thursday, Your Honor, but Attorney Castillo can stand in.
I'm happy to stand in.
Okay. Mr. Tipton, with a thumbs up or thumbs down, are you able to do Thursday at 2, even if only on Zoom? That's a thumbs up. Okay, Thursday at 2. Thank you.
All right.
Attorney Beatty, what do you think?
That's fine, Your Honor.
We'll just get our own
Thursday at 2?
Zoom on Thursday.
Judge, in the interim, may we get a copy of the Como
Fine.
motion to intervene?
I'm not prepared to provide that at this time. I will consult with our counsel, and if he advises us that it's appropriate, I can do that.
At a minimum, I would like
I'm going to try to go find that.
a copy shared with myself and all counsel.
Oh, the court's just
Even
making it
if-
happen.
The content of any confidential information or confidential material has to be redacted from that filing. So I don't know if in your filing, because you're obviously privy to the confidential information, not necessarily you, but others in your office are privy to confidential
What a
information.
mess.
That's the reason that I'm not sharing it. There's
Okay.
nothing in there that's confidential. That's not the reason.
So if the
Then
only
what's the
reason
reason?
is that it relates to an impounded proceeding in the federal court, the fact that it was filed in that impounded proceeding, I don't believe
Oh.
entitles it necessarily to
I can't get that
be
done.
impounded for all purposes.
Again, I'm going to rely on the advice of counsel.
I'm not suggesting you do anything else, and I'm not ordering it to be disclosed right now. I'm taking your representation
He
as
wants
to
it
what
to be
relief
disclosed.
it seeks. We'll deal with this again on Thursday at 2.
And I think the other concern would be that if we shared it with counsel, what would they do with it as well? I think that's.
You can put a protective order on
I think we're trying to
that.
keep apprised of what's happening in the federal courts so we can make decisions most intelligently here, and so that I don't do anything rash.
No, I appreciate that. I would ask for an agreement that it not be shared or disseminated outside
You need a
of
protective
counsel.
order.
That's what I'm saying.
Every piece of paper that's been generated in this issue has had a protective order. We don't have a problem with that, Judge.
Okay.
No objection on behalf of Mr. De Los Santos on that limit.
Yeah, the defense attorneys are like, I don't give a fuck. We don't intend to share it. We need the information. The defense attorneys are more focused on doing their job for their client than they are on anything else. And the DA is asking for essentially a protective order saying if we share this, we need to make sure it's not shared outside because the proceedings impounded, it won't be public. So we won't have that. Rebecca wants to know, so what is Welsh's full name? It's Brian. It's Massachusetts. Everyone's named Brian. It's Brian. Everyone's named Brian. Mm-hmm. Apparently lately we only cover cases if someone is named Brian. I don't know. It just is.
A discrete issue.
Okay, and with respect to, so that's Mr. Cataldo? All right, any problem with that, Mr. Tipton?
Mess.
No problem.
Yes, no.
I can hear
He's
you
shaking
now.
his head no.
He
Okay,
said
very
no
good.
problem.
In the Walsh matter, I have the Commonwealth's motion for protective order, August 5, production of chats, and Commonwealth's motion for state court protective order covering materials subject to federal court order. Those were signed by prosecutor and defense counsel. I've allowed them and issued them as so ordered. So.
Yeah, I'm Paula Self submitting for Myles King and for Sean Johnson as well. That's been endorsed by both parties.
Okay.
And I will.
I did make one amendment to the King and Johnson on page 3, in that paragraph saying, because the Commonwealth agreed that I could share the information with my clients, but not the actual document. He can't get a copy of the document. So I made that change on that. I just want to bring to your attention, Judge.
Ms. Hickman, did you see that?
We did, and ADA Beatty saw it as well, and we are in agreement with that language.
Okay, so it would read, let's see.
The defendants are able to view the chats, Your Honor, but they just cannot get copies of the chats that are being produced.
Not duplicate or provide a copy of the text messages to any other person.
Correct.
Okay.
And Your Honor,
Okay.
we'll get the printed for Mr. Cataldo and for Mr. Kowski, and we'll submit them by the end of the day so they can have their text message, the chats as well today.
I'm prepared to sign one
Which means some of the Proctor texts are included in the motion that's impounded for the feds.
subject to the same modification, Judge.
Okay.
It was emailed to me, but I was already en route to the courthouse.
All right. Let me just act on these with respect to
So there's a
Mr.
protective order
King.
going into place.
and Mr. Johnson.
Okay, so they're putting in a protective order
And I
regarding
just
the
had
motion to
one issue I wanted
intervene.
to address before we.
Sure.
I'm not going to be here Thursday on behalf of Mr. De Los Santos, but just so I'm clear of the landscape, I know we're keeping it a short
Here you go,
date
Jim.
so we get a better appreciation of what's going on in federal court. But if I understand this court correctly, are you also contemplating an order that would order the Commonwealth to begin reviewing those materials for potential Rule 14 information?
Right now, I'm contemplating an order that explains why I put this off 2 days. And I may have time to do that today, and I may not. Maybe not till tomorrow, but I am. So we'll see how far I get on that.
All right.
Okay, but in any event, we'll have further hearing on Thursday. Okay. Anything else?
Thank you,
No,
Mr.
thank
Lerner.
you.
Okay.
There is a protective order on Mr. De Los Santos related to promises and rewards and
That's
inducements.
with a different DA.
Okay. Joe, just before we conclude, I wanted to address that today, right?
Yeah, okay.
Wow. Wow.
Oh, right.
Wow.
You're just filing this, right?
All right, well,
All
Thursday.
right. Can you just identify yourself for the record?
Good afternoon, Your Honor. Jennifer Player for the Commonwealth.
Okay. And this is in the Chanchillo, Dos Santos, and Johnson matters.
Yes, Your Honor.
Okay?
Good afternoon again, Your Honor. Rosemary speaking on behalf of Mr. Johnson.
Okay.
Your Honor, the Commonwealth.
Hang on. And Mr. Krowski?
Attorney Gross on behalf of Giovanni De Los Santos.
Right.
And Attorney Joseph on behalf of Bianca Chanchillo.
All right. And on each of these three cases, I have the Commonwealth's motion for protective order regarding witness identifying information.
Yes, Your Honor, the Commonwealth became aware the week before last in speaking with a sergeant from the State Police Violent Fugitives Unit that there was an individual that was involved in assisting them in the apprehension of Mr. Johnson, who they were unable to locate for approximately 8 months after he was indicted. And that sergeant indicated to the Commonwealth that the individual that assisted them with information was given a reward for that information, a monetary reward. The Commonwealth asked the sergeant for the particulars surrounding the circumstances, who the person was, identifying information, how much money, et cetera. We asked them to reduce it to writing. That was done. It was provided to me yesterday afternoon, and the Commonwealth is prepared to provide that information to counsel. However, contained within the information is the fact that that individual is in fear for their safety if their information is to be disseminated to individuals other than the attorneys, and therefore the Commonwealth is asking that the information be provided under a protective order and limited to the information to the attorneys themselves.
Okay. You've seen these motions?
Okay. We're just, what? How is the just one more thing this? What?
Speaking with
I'm backing this all the way up, chat.
The Commonwealth's motion for protective order regarding witness identifying information.
Yes, Your Honor, the Commonwealth became aware the week before last in speaking with a sergeant from the State Police Violent Fugitives Unit that there was an individual that was involved in assisting them in the apprehension of Mr. Johnson, who they were unable to locate for approximately 8 months after he was indicted. And
so there was an informant of some sort. So Violent Fugitive Unit had an informant. The informant helped them find Johnson. Johnson got indicted. Johnson was in the wind. They couldn't find Johnson, the defendant, who's in custody. They couldn't find Johnson, the defendant. And a tip helped them find Johnson. That information needs to be turned over, but they want to make sure that that information doesn't get to the defendant and that person's name doesn't get out there because that person's in fear for their safety, which makes sense. So they don't want their name out there. So it's about the person who is in the wind is Defendant Johnson, one of the 5 cases that's here dealing with the Proctor fallout. It's Rosemary's other client. Different case. Not related to any of these cases. There are 5 separate cases dealing with discovery issue. The reason all 5 of those cases are on calendar at the same time is because they're all dealing with the same discovery issues with regard to federal discovery regarding Proctor, because Proctor is the tipping point of these problems because he was investigating all of these cases. But as to Defendant Johnson got indicted and they couldn't find him to arrest him and put him in custody. They got a tip to help them find Johnson. Just keep going. And they need to disclose that because that person got a reward. So there was probably some kind of reward out there. But that informant got a reward. That has to be disclosed to the defense because there was a monetary compensation. but they want to make sure that the name of the witness is not given to the defendants so that that doesn't get out there. That's what they're talking about. So this is a different DA talking about a different case. The tip that found the Johnson. Yes.
That sergeant indicated to the Commonwealth that the individual that assisted them with information was given a reward for that information, a monetary reward.
And that has to be turned over.
The Commonwealth asked the sergeant for the particulars surrounding the circumstances, who the person was, identifying information, how much money, et cetera. We asked them to reduce it to writing. That was done. It was provided to me yesterday afternoon, and the Commonwealth is prepared to provide that information to counsel. However, contained within the information is the fact that that individual is in fear for their safety if their information is to be disseminated to individuals other than the attorneys, and therefore the Commonwealth is asking that the information be provided under a protective order and limited to the information to the attorneys themselves.
Okay. You've seen these motions?
Yes, Judge.
Okay. Is there an opposition to the motion?
I do object on behalf of Mr. De Los Santos.
Okay.
I would, subject to the court's approval, meet them halfway. I think that my client being charged with homicide is entitled to know who is accusing him or so-called co-ventures of what. At this time,
I don't know if I'm going to agree with the defense on this. If this person is giving information about where to find and arrest a defendant and not information regarding the substantive crime, then I don't know if that's the same as it goes to not even a co-defendant, but as it plays into all of this. If they have substantive information and they're going to come into court and testify, different. But if it's just about locating an accused who's been indicted, it's not really a confrontation issue because he was in fact found. It doesn't go to the underlying case. So I don't know if I agree with the defense on that, but we'll see.
I would agree not to share the actual hard copies of the paperwork if there's any concern about
I don't think this is a
dissemination with
confrontation
any
issue.
facility. However, for him to prepare for his own defense and participate meaningfully, he has to know who's accusing him or his co-defendants of certain conduct. I would imagine that the government, and they're being tried together, is going to try to use this information as potential consciousness of guilt. That name...
They are co-defendants. So Johnson and the other defendant whose attorney is talking are co-defendants. Fine. He's saying, look, if him being gone is going to be argued as consciousness of guilt, the flight is part of it. Like where law enforcement found him and how they got there is separate and aside.
Probably will mean nothing to me, but might resonate with my client. It might be a person that he has problems with. It might be a person that he has specific firsthand information of as it relates to bias or credibility. And again, if you look at the pleading,
I don't necessarily agree, but they're going to make their
only a very
argument.
Generalized assertion that the witness has fears for their safety.
Yes.
I would imagine, having done these cases for many, many years, that if you poll just about every civilian witness in a first-degree murder case, they would express some sort of generalized concern for their safety. There's nothing laid out in affidavit giving an individualized, particularized assertion of why they're afraid for their safety as it relates to Mr. De Los Santos. So again, in the spirit of compromise to move the ball forward and have my client, who's got idle time on his hands, participate in his defense.
Your Honor,
I would
he's
agree
just
not
sitting
to
there.
share the actual documents with him, but I would ask that you allow me to bring the documents and review them with him when I meet with him.
So I join in what Attorney Kowski says, but I have a bigger issue, which is another issue we're dealing with in a separate case, but where has this information been for 2 years? How did the Commonwealth just get it last week or the week before? How have they not gone through the files
And this is Johnson's defense attorney, Rosemary, who's saying, excuse me, he was arrested 2 years ago, Your Honor. How the fuck are they just now identifying a witness? I mean, fair.
And determined what evidence they had. Why are we just finding out about it now? And that's my concern.
That's a fair point.
I'm going to ask that you order the Commonwealth to file a certificate of compliance in the Johnson matter, so that we are sure that we have all of the information, that the Commonwealth has done their job, that they've met with these people, and that we're not going to keep doing this where we can't schedule a trial date until we have a certificate of compliance to understand what's going on here, Judge.
I would join that request and ask that it lay out specific dates of when each piece of discovery was turned over.
Attorney Cataldo?
Yes, I too object, Your Honor. I think the defendants are entitled to know who their accusers are and who witnesses are and who people, informants might be in a circumstance like this. To the extent this court were not to allow it, I'd ask the court to at least do it without prejudice, so that after we find something out about these individuals, we can come back before the court to then see if that's something we should share with our clients. Because ultimately, it is our clients who may or may not know these individuals and may or may not know the relevance of these individuals to the case and to the defense.
All right.
We shouldn't be operating blindly.
Attorney Blair, defense counsel are giving you a range of other options you could fall back to.
Your Honor, what I can say is that it is put forth in the motion. The state trooper did speak to the individual who expressed their concern. And, Your Honor, this is a witness who assisted in locating Mr. Johnson.
Not an accuser.
This witness did not make
enough.
any statements about any of the other co-defendants or about any of the merits of the case, just merely the location of Mr. Johnson.
How do we know that?
It's being represented. And for those of you like, why is Brian Walsh just sitting there staring at the Zoom hearing? Because his case is on for hearing today too, even though this is not about him as a defendant. So he's still on the Zoom. And the court is looking at the motion, it looks like. So that's why he's just sitting there. This is not related to his case. There were 5 cases on docket. And so they're just kind of jumping back and forth between the cases, which some of the judges I worked with in California would lose their minds over. They're like, we're calling this case and taking care of these issues, then this case, then this case, then this case. And now he's just like, okay, well, I'm just going to sit here and listen.
How do I not
Nothing else to do.
allow counsel to communicate with their clients about a witness who's going to be testifying or might testify?
Not a witness.
Or
That's
they
why.
even might call to testify.
Because probably not a witness.
To a matter relevant to the case.
Well, Your Honor, the Commonwealth will not be calling this person to testify.
Right, because they're not a witness
It
to
was
anything.
8
They're a
months
snitch.
after the case. It was merely a location. Your Honor, I would submit that that counsel could review the information. The Commonwealth will not be calling this witness. Counsel can review the information.
Right, there are snitches to his
And if
location.
they determine that this is somebody that they would want to call, they could come back to the court and ask for the order to be modified. The Commonwealth is concerned that there is a significant
risk of harm
issue for this individual if the identifying information is revealed to their clients.
But Judge, I guess I'd ask with respect to Mr. Johnson, what's the safety issue? Other than generally he doesn't want.
I know exactly
anyone
what
to
the
know that he
safety
got
issue
paid
is.
To give up Mr. Johnson. I understand. That's not enough of a reason not to allow Mr. Johnson to investigate.
I understand
this.
what
What if it affects 4 other witnesses in the case? I don't know that, but I don't want to be in a position where I have a trial date and I'm finding out on the eve of trial.
Right. I understand. If I was the defense attorneys, I wouldn't trust shit either. If I was the defense attorneys, I would be like, Your Honor, the fuck that we're finding out about more people. But I also understand where the Commonwealth is coming from. The Commonwealth is like, look, This is not a person who's a witness. This was a confidential tip, or not really, well, they're hoping to keep it confidential. This was a tip as to where somebody's location was. And that could be something they saw him on, I don't know, Snapchat or whatever. And are like, I know Johnson's kicking it at whoever's place. That's where he's at. There's a reward. Give me my money. But because there was an exchange of money, that has to be disclosed. So law enforcement can talk about where Johnson was arrested and how long it took. They don't need the witness to come in. The defense is like, you never know. But I also understand the Commonwealth saying, yeah, but if this person's name hits the streets, that becomes a huge safety concern for this individual. Well, Commonwealth, if the court makes you turn it over, then you need to put that person in protective custody and move them wherever they move them. In California, it was much easier. It's a big state. You can move people. The problem we had with putting people in protective custody is that you take them out of their environment, you take them away from everyone they know and everything they know, and they tend to come back. And that becomes a whole other problem. So it's difficult. But the defense attorneys are like, we got to do our job. And the prosecution's like, we don't want to put this person in danger because the prosecution needs people to give them information. And if the people who give information end up not being protected, then people are going to look at the Commonwealth and be like, I'm not saying shit to you. This is not a me problem. So I get it. But it's a really, really difficult thing. And I dealt with a couple, I'm sensitive to this. I dealt with a couple cases that involved, one was a witness killing and one was a couple that were harm to witnesses. And it outside of the interpersonal violence space, it's tough. So I get where the Commonwealth is coming from, but I also understand the defense attorneys being like, we don't believe you that there's not more here. All right. And I don't blame the defense attorneys for that.
That this witness, who they said was nothing, ends up being way more than that, Judge. And we can't make that determination without sharing the information with our clients.
The witness assisted the state police in locating the defendant years ago, right?
Yes.
The promise, reward, or inducement was paid to that person years ago.
Yes.
So all of this information should have been turned over to defense counsel years ago.
Bing, 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 bing.
Right? Presumably, you know.
The court gets right to the point. The court gets right to the point. Why the fuck is this just coming up now? I have empathy for the person who's like, if my name hits the streets, I'm deeply scared. I get it. I completely get it. Can't say that that's not an accurate fear. That's an accurate fear. But the court's like, okay, can we just... This happened years ago. Why the fuck does this keep happening? How many times today? Oh my God. And I imagine the DA is going to say, as we're watching this all live together, the DA is going to say, we were just told about it by law enforcement. This was a Proctor case. We were just told by law enforcement, by whoever took over this case, was like, oh, did we tell the DAs this? No, maybe we should, maybe we need to share that information. You think? Fucking hell. I'm going to back up the court real quick.
Right?
Yes.
The promise, reward, or inducement was paid to that person years ago.
Yes.
So all of this information should have been turned over to defense counsel years ago, right? Presumably, you know, that's the first promise, reward, and inducement paid by the police in connection with this case. Presumably, I don't know. Maybe there were others.
What the fuck? Say it, Your Honor. You want to. Your face is saying you want to say, what the fuck?
That there's been any issues with respect to this person. May not be known to the name, may not be known to the defendants. Or maybe the defendants have had some suspicion, or Mr. Johnson has had some suspicion but hasn't known who it was who called the police about his location. I don't know. Where was Mr. Johnson apprehended? California.
No,
New York?
no, he was not, no.
In Massachusetts?
In Massachusetts, in Webster, Massachusetts.
In Webster, okay.
How were there three very wildly different answers? Where was Johnson apprehended? California, New York, Webster, Mass. How the fuck are there such wildly different answers? And who's answering? What's happening?
Bruh.
Oh my God.
All right.
Oh, Dr. B is calling me. Hold on. I'm going to put this on. I'm going to mute myself.
Called the police about his location. I don't know. Where was Mr. Johnson apprehended? California.
No,
New York?
no, he was not, no.
In Massachusetts?
In Massachusetts, in Webster, Massachusetts.
In Webster, okay.
I apologize.
All right. All right. Okay. I'm going to allow the motion for protective order, except that the name of the person can be shared with the defendants. Any documents containing the name or address or other identifying information, that any written documents, okay, will not be shared, but the name can be shared with the defendants.
Thank you.
So these motions will be allowed, except that the name can be shared orally, okay, with the defendants. And that will be without prejudice.
Once the name is shared, Your Honor, it doesn't matter if it's on paper or not. Once the name is shared, the name is shared. I mean, for the witness, that doesn't really help, right? Because I don't think they're actually a witness. But again, if I'm the defense, I don't believe the prosecution when they say this individual just gave us a tip of where we were going to arrest Johnson. I don't believe that that's it. And the defense is like, no, I want to know from my client if this is somebody they've got beef with. I want to know from my client if they know this person. I want to know, because then I need to go interview this person. The problem is that if that person's in fear, they're not going to want to talk to anybody, but this information is not going to be used in trial. So the information is not going to be used in trial because where the defendant was found is going to be testified to police. And police are going to say, we went this place, we saw Johnson, we knew it was him because of this, and then he was arrested. And he was evading us for 8 months. That's what they're going to say. Oh boy. All right, let's continue on.
To renewing a request for further disclosures if necessary.
Thank you.
Priya, the defendants will be told by their attorneys not to, but that's not going to stop anybody.
All right. Now, anything else?
And the defense attorneys, I'm sure, are going to say, if anything happens to that individual, you're going to be the first person who's going to get fucked by that. So, and all jail calls are recorded, but I'm going to stop there. Things tend to get out is the problem. For those of you asking about my shirt says because I was inverted. I think we can only see the because. Because that's how I feel every time I'm in Massachusetts. Right now. And I love Massachusetts. But these courts are making me feel like I am literally upside down. Like this.
Else that we need to do with on this cluster of cases? This 3-code D case or the others?
I would just ask on behalf of Bianca Ciancio that she'd be excused on Thursday. Attorney Scott Pichu is standing in. She's out on cash bail.
I'm happy to have any of the defendants who wish to be excused on Thursday. I don't know if either of the defendants who are here in person want to be brought in again. I know it's a hassle to be brought in, but if you want to be brought in, we'll bring you in.
You have the right to be there,
They
right?
both have said yes.
They both, yes.
Santos wants to be.
Okay, Mr. Johnson would like to be here.
Okay,
And
fine.
Mr. King is out on bail, and he'll definitely be here.
Okay, very good.
One last issue.
Yes.
I had filed motions last
One
time
last.
with the court, and he was then subsequently interviewed by probation.
One last issue. One last issue. One last
Sure
issue.
whether or not he qualified,
All right.
and you were just waiting
On,
authorize those motions subject to.
King is not in custody. The court, as a remedy for discovery violations, allowed King out of custody.
That interview and
So King's not in
have that
custody.
information?
It seems like Johnson is in custody.
Okay, all right.
Is it Del Santos?
Yes.
I'll take a look at those motions for funds.
I'll look too.
Okay,
Maybe.
thank you.
And then just do a separate matter with Mr. King.
Yes, we do.
And now there is a separate matter as to Mr. King.
Turns over.
Judge, just while I'm waiting for everyone to come in and out, Christopher Rando, Mr. Nelson, and Mr. Amanu.
Okay, thank you.
So now another matter on the King case.
You.
Okay.
It's on for, Mr. Rando, you're good right there.
Goldie, yeah, they let King out
Could I
in
just have counsel identify
June.
themselves for the record, starting with the defense
This is
attorney?
very recently.
Good afternoon, I'm David Arnold, John Nelson for Mr. Rand.
Thank you.
He's present in the back. It's on for pretrial conference.
Sir, you can be seated. Okay,
So, in speaking, I believe I have all the discovery other than the drug file.
okay, so we're just waiting on that.
We're going to request the date of either the 14th or 15th of October for pretrial hearing and filing of any motions. I think we could.
Do you anticipate any motions?
Maybe a motion suppression.
Maybe.
It was
This is a different case.
Motor vehicle stuff.
Okay.
I think 10:15 works better, if that's okay. 10:15.
October 15 at 2.
Thank you.
Thank you for your patience.
That was just a new date on a different case. I'm waiting to hear
And now we're
what,
back on the Myles King matter.
yeah, the King matter. So back on the record in the King matter.
Good afternoon, Your Honor. Michael McGee for the Commonwealth.
Okay, Mr. McGee.
Good afternoon again, Your Honor. Rosemary speaking on behalf of Mr. King.
All right.
Good afternoon.
Nicole Scapici on behalf of Mr. King.
Okay, Mr. King is here.
Good afternoon, Your Honor. Dan Moynihan on behalf of
Mr. Moynihan.
I filed an amendment motion late this morning.
I saw that, yes.
Lots of
So
attorneys.
I was given a piece of
The
work
King
product,
case.
page 1 of 36,
Correct, Your
which
Honor.
looked like well, you tell me what it is.
So, Your Honor, you gave us, or counsel, 2 tasks. One was to provide a list of.
Okay. We're finally back to where we were last time. I feel like that deserves a swoop. We are finally resuming where we left off in the King case at the last hearing. So let's reset because we have been live for 2+ hours at this point. As I said much earlier in stream, last time when we left off in the Myles King case, which is a homicide prosecution in Massachusetts that is dealing with discovery issues connected to former Trooper Michael Proctor and attorney Adam Lally. The court had asked the prosecution and the defense to merge the lists of what discovery was turned over and when. That was one of the first thing. The second thing was, and what items does the defense argue are exculpatory Brady Giglio material? So what's late when it was turned over? We know there's stuff that's late. The court has already made some remedies for how late discovery was. And then separately, what items are exculpatory? So those are the 2 issues. The court said, everybody just put your heads together and figure this out, and then get together and tell us what is going on, because the court can't continue the evidentiary hearing part of this, which is having Lally, Proctor et al. On the stand, until they narrow it down to which documents need to be questioned about, because it's so much that was late. The late is just step 1 of the problem. So we are now getting into, okay, back in this case, now what's happening? Oh boy. All right. So back to the King case.
All new discovery and any disputed, whether it was new or previously
the
provided.
DA?
Yep.
In a joint form. That is what you have before you. You also asked counsel to identify which of those documents were exculpatory or items and information favorable to the defendant that you do not have.
Okay. So let me just see if I understand this correctly. And I didn't have a chance to compare this earlier against the notices of discovery, but let me just take a look. So you start with notice of discovery 26, and these are numbered 1 through whatever it is, 8, because there are 8 things in the notice of discovery 26. You've listed the description, which is the same description given in the notice of discovery, as best as I can see. And then there is an agreement on the right-hand side. If it says why, you both agree as to defense notes, which was it that was not previously produced. Okay, if there is a no in that last column, it indicates
What? So now when all the attorneys are back in court, they killed the Zoom portion of the hearing. I wonder if there was, well, I'm not going to speculate. What? We just got to the Zoom part of the hearing regarding the King case that we had been waiting for since this morning. And the Zoom hearing is cut. And I don't think the pool camera ever came back. So let me go see if the pool camera ever went back and shared. They might not have. I'm going to reach out and ask them if they recorded the rest of the King hearing. But the court cut the Zoom feed and the pool camera cut before any of these hearings ever got started. So, what happened in the Myles King hearing today? We don't know. Because by the time they finally got to the Myles King hearing today, the Zoom hearing that had been streamed was gone, and the court stream ended before they even got into all of these hearings. The access to what is going on in court at times is incredibly frustrating. We just need our own cameras at this point. Okay. I'm going to have to check the docket. We're going to have to see what happened. But the host of the Zoom meeting ended the Zoom meeting. So we won't know what's going on with discovery in the King case until we check the docket and it's updated. So I will check the docket and see when it's updated. However, there is going to be a hearing on Thursday. We will see what's going on the hearing on Thursday, and we will figure it out. I'm frustrated. You're frustrated. We're all frustrated. Maybe, just maybe, the pool camera that was in court will post the rest of the hearing. I will reach out and ask, because I want to know what happened in the King hearing. But what we heard the DA say is that the court has a filing that shows what was turned over and when, but does not have a filing that shows which documents are exculpatory, which means the court at some point is going to say, go do this. Michael J. Money said, I want so badly Baker Media pool cameras. I do too. It is difficult to navigate and expensive AF. But yes, same. We are trying to figure out how we can make that work. So, yes. But, however, I did see Sue O'Connell from Boston 10 in the courtroom. So let's see if she posted anything on the Bird app. Nope. I mean, I saw her in court when everything cut, but I don't see any post. Ted Daniel posted 40 minutes ago saying attorney, so it sounds like he was in court too. Attorneys for 5 defendants connected to murder cases, so separate murders in Norfolk County, were back in court seeking the federal download of Proctor's phone and potentially other phone data from Proctor that's not included in the federal materials. Proctor's lawyer said nothing exculpatory exists outside the federal materials because Proctor got a new phone in February 2024. Shocking. Part of the problem here is that there is a ticking time clock. I'm going to start singing Dave Matthews in a second. That's a deep cut. But there's a clock on this discovery because there was consideration about whether or not that information would still be preserved by the feds. And so whether they will get it before it is just gone, I can't imagine why the feds would do that. There's a lot more motions I just need to pull regarding that tolling. But also the reason that Norfolk DAs or state police can't just go extract Proctor's phone is because my understanding is that the extraction that exists that the feds have is the only one that exists and everything else is gone at this point. Either by it rewriting from iCloud, getting a new phone, the rest of it. So they can't go get Proctor's phone now. They have to get it from the feds. That's my understanding of where we're at. So it's been 85 years. We wanted to know what was going on in the Myles King case, and we don't because everything cut. So we will have to wait and see. Here's what we learned today in the extensive discovery hearings that were ongoing in, I think, 4 separate cases with 5 separate defendants, including the Brian Walsh case, which many of you know of. It's a higher profile case, the Myles King case, and others. The fight over federal discovery is not done. And the prosecution, if the best I can summarize this, the prosecution is in a unusual and difficult position with regard to the federal discovery. We're not going to talk about the late discovery at the moment. With the federal discovery regarding Proctor and whatever else. The issue with the federal discovery is that the prosecutor on the Walsh case, one of them, is Attorney McLaughlin. Attorney McLaughlin was also on the Reed case. Attorney McLaughlin is aware of what is in the federal discovery that was turned over to them in the Reed case via a TUI request. The TUI requests in the other prosecutions were rejected by the feds. They sent the request for discovery and the feds said, no, we're not giving it to you. In the Reed case, it was turned over. However, there's a federal protective order with the information in the Reed case. It cannot be used and disclosed in other cases. It does not say disclosed. The court read the language verbatim and it said it cannot be used in other cases. Here's the problem. Attorney McLaughlin knows that it exists. And the Rule 14 obligation for Attorney McLaughlin is that if you know of anything that exists, you have to disclose it to the defense. But they don't have it such that they can turn it over because of the federal protective order. But the judge said, but you have it, even though you don't have it. someone in the DA's office has this information, but the federal protective order says you can't use it in another case, but you have it. And because Attorney McLaughlin is aware of it, she has to disclose to Defendant Walsh's attorney, I am aware that this information about the lead investigator exists. It's potentially exculpatory. It's at least impeachment as to Proctor, the lead investigator. So I have to tell you it exists, but I can't give it to you because of the federal protective order. But I have to disclose it to you. And the court's saying, but if it's disclosed and then you can't turn it over, aren't you obligated to review it to confirm that there is no exculpatory material in there? And the Commonwealth said that their position is they can't review it to determine if there's potentially exculpatory information because of the federal protective order. So do you see the circle that we are in now? It's been disclosed. It can't be turned over, they say, because of the federal protective order. It's not being reviewed further as to the Walsh case, because when Attorney McLaughlin went through this, she was looking at it for the Reed case, not the Walsh case, and can't review it again for the Walsh case because the position of the Commonwealth is that they can't, reviewing it is using it in another case and they can't do that. But she can't Men in Black flashy her brain and forget that it exists. And Attorney McLaughlin knows it exists and has to tell the attorney because she knows it exists because she reviewed it for the Reed case. But she can't turn it over to them other than knowing that information exists regarding Trooper Proctor. And she can't review it again because of the federal protective order. But the defense has a right to any potentially exculpatory information. And the Commonwealth won't affirm that it's not exculpatory because they haven't reviewed it again. And the defense is like, well, then you need to turn it over to us. And the Commonwealth is like, we can't because of a federal protective order. And the court's like, what are the feds going to do? And the Commonwealth made a motion to intervene in the federal case to get the discovery. And the feds, in the letter that the court read on the record, said, we think it's inappropriate for either the defense or the Commonwealth to intervene in this case. So the feds are objecting to the Commonwealth of Massachusetts intervening in the federal case to get this discovery. So they are disinclined to acquiesce to that request and turn it over. The court at one point said, so has anyone subpoenaed the Reed attorneys? And the attorney that spoke in court said, I think it's an abuse of the subpoena power to subpoena Karen Reed's defense attorneys to try to get this information because they're covered by the same protective order that the Commonwealth is. And I lost my mind and said, it's not the job of Reed's defense attorneys to turn this information over. And they're subject to a protective order. It's the Commonwealth's job. And the Commonwealth's like, but the feds told us to fuck ourselves. So, my summary. So what are we supposed to do? So we are in a very strange, every time we're in Massachusetts, we're in a very strange scenario where at least one attorney for the Commonwealth on one of these murder cases is aware of information that is potentially exculpatory to the defendant, but cannot review it more and cannot turn anything over more specific than that because of a federal protective order. And when they sought to intervene, the Fed said no. And when they asked for it to be turned over, the Fed said no. So the defense attorneys have an argument that this is potentially exculpatory information that can't be turned over, and that becomes irremediable. But then they have to argue that it's potentially exculpatory based on what is publicly known, which goes to the Reed case, not their defendants. They don't know if Proctor said anything about Walsh or any of the other defendants. They don't know. But they have to argue that it's potentially exculpatory, but under the case law in Massachusetts, they have to prove that it's exculpatory. And you're all going to ask me, Emily, how do you prove something's exculpatory if you don't know exactly what it is? Exactly. And then we're back to the court saying, but you need to review it. And the prosecution saying, we can't. And the defense attorneys are saying, then you have to dismiss our cases. And the court is saying, I need to know what the federal court's going to do, which might be a 2-week hiking trip. She threw in there some, it's oddly specific hyperbole. So how do you argue something's exculpatory to get your case dismissed if you're the defense attorneys when you know kind of what it is, but not entirely? And if you're the court, you can't order the federal government to turn it over. But I mean, I guess you can issue a subpoena and hope for the best, but it's not going to go very far. And you're stuck in a freaking boot loop with a blue screen of death going, the files are in the computer. I mean, they existed, but we can't tell you what they are. But they existed, but we can't tell you what they are. The remedy I would like to see, this is just personally, the remedy I would like to see is that the feds turn it over to a discovery referee, mediator, retired judge, whatever. That person reviews it and turns it over. I don't think the DA's office should be the one deciding what gets turned over in this case from the feds. And I don't think the feds should be deciding either. But we are in a very strange procedural quagmire where the feds are like, we're not giving it to you. And we have a separation of powers here where the court in Massachusetts might be left with no remedy but looking at these motions to dismiss. And the case law in Massachusetts says you need to show that it's exculpatory. And how do defense attorneys do that if they can't see what the fuck it is? I'm so incredibly frustrated by this loop, and potentially exculpatory is the language used often, but that's not what it says in Massachusetts. They have to prove that it's exculpatory. For all of you asking, and many of you are, why won't the feds turn it over? I don't know. I don't know what else it is. We know a very limited amount of what it is from the Reed case. And we know that some of the text messages from Proctor are the text messages from Proctor. We don't know what else the feds have. What I will say is, if it weren't for how public the Karen Reed case was, I don't know if all the defense attorneys would be as aware as they are of what's going on. Because there's no way Attorney McLaughlin cannot mention this, because everybody watched this case play out. So there's at this point, there's frustration, but there's no hiding that this exists. There's no not disclosing it. We all know that the Norfolk DA's office, some members of the DA's office know what at least some of this material is. We also don't know if the Norfolk DA's office has all the materials. And if the Norfolk DA's office is in part a target in any way of these investigations, I can understand why the feds are like, I'm not giving you the stuff about you. No. But the result can't be that the defense attorneys don't get this information either. And I don't know if there are multiple things going on with the feds. Kelly said, why did the feds give it up for Reed's case? I don't know. And I don't know if it's the same federal attorneys dealing with both cases. And I don't know if it could be that there are different attorneys on different cases. It could be that different things are being looked at now than then. I don't know. And I'm not going to speculate on that. It just won't be helpful. But there's a lot of possibilities. But the defense has a right to potentially exculpatory information. If Proctor is going to testify in these cases as lead investigator, the defense has a right to cross-examine him about not just being fired, but about the rest of it. They have that right. But how can they do that if they don't have all the information? And I understand the prosecution saying we can't violate a federal court order. The prosecution's not wrong. They can't violate the federal court order. the court is going to have to step in and help interpret that court order and say, I interpret that court order as you cannot use this information in any other case but the Reed case, meaning you can't use it to prosecute another defendant. But that doesn't mean you can't review it and turn it over. So it might just be that the court has to make that order saying, my interpretation of the federal protective order is this. I am finding that your review is not a violation of the federal order. But if the feds disagree or if that gets overturned, then the prosecutors put themselves at risk by doing that. So I think you make Lally do it on all the cases because he's already seen it. Put Lally on all the cases and make him deal with disclosing it. If somebody's got to take it for the team, then Lally is the one who has to disclose it because he's the one who had the most access to it. Go ahead. But the state court is waiting to see what the federal court is going to do. And right now the federal court the federal court hasn't done anything yet. But if the prosecution and the defense aren't going to be allowed to intervene in the federal case and get this information, then it's going to be up to the state court to make a determination that it's not a violation of the federal order. Or the court has to say, yes, you doing this would be a violation of the federal protective order. And you not turning it over is a violation of, Rule 14. But then what's the remedy for that? Wild. Because the remedy for that, if the court finds it to be exculpatory, the remedy for that can be a dismissal because a new trial can't fix it. I appreciate what a mess this is. I don't know what the right solution is, but it's definitely something that's A, going to have me scratching my head, and B, talking to every attorney I know and be like, what? And pulling up a bunch of case law. But my solution, Emily, your solution is not great. My solution is throw Lally on it. He had the most access to it, or the lead DA, the elected DA. Then this becomes a Morrissey problem. You don't send your lying deputies to deal with this. You deal with it. You're an attorney. You're the elected DA. You deal with this discovery quagmire. Go ahead. But the DAs can't violate an order. I don't know if the court can order them to review it. And I don't know if they can follow that court order if their interpretation of the law is different ethically. Like if the court orders you to do something that violates your attorney ethics, then your obligation is to deal with the consequence of not adhering to that court's order, which is a whole nother thing. So I don't know, throw Morrissey or Lally at it. That is my snarky response. I think the thing that makes the most sense is to, if the feds are inclined to disclose it, which it seems that they're not, to disclose it to an intermediary. And that has to be the thing. What an absolute mess. Someone has to take the lead and make some decisions in this. And it seems that we are in a time crunch to do that. But also, here's the question I'm left with. If the federal investigation was over, why is there so much of a fight over not disclosing this information? That's my question. The feds refused to modify the order. They refused to let anybody intervene, and they're not turning it over. If it was all done, why wouldn't they just turn it over? And perhaps it's because what they were looking into in the Reed case might be done, but what they're looking at in other things might not be. So yeah, they might be done with looking at the Reed case, but the Reed case isn't the only case. So yeah, here's ARCA. Here's what Proctor said about Reed. But my gut on this is that there's just more to it. The feds aren't done, and that's why they're protecting this information. But I don't think the feds are inclined to charge Brian Walsh with murder and prosecute it themselves. Or any of these other cases. You can't violate a defendant's constitutional right to protect them or to prosecute them. I think the situation might be, and this is me speculating, that what they were looking at with regard to the Reed case is a part of what they were done working with ARCA with enough that they were like, go ahead, you can hire ARCA. We're done with ARCA. We're done with talking about Karen Reed. We're done with the see you next Tuesday text messages. But that doesn't mean we're done with Norfolk. That doesn't mean we're done with Proctor. And that doesn't mean we're done. And they don't want the DA's office to have the information. So take from that what you will. But it seems to me it's because they are not done. But I'm done with the fuckery of trying to get to court today. Good God. We're going to have to figure out Thursday. I'm going to reach out to the court and get access to the Zoom. If the court says that there will be no streaming the Zoom, I will not stream the Zoom, and I will review the Zoom and summarize it later or in the podcast. And then we'll stream earlier on Thursday. If I can stream the Zoom, then we'll just do that. If there is no Zoom, I'll try to figure out what NBC 10 is doing. And if they recorded the rest of the hearing, I want to know. And tomorrow we're going to cover Adelson because at least I already have that hearing because it's done. Tomorrow we're going to jump back to Adelson. What a mess. Oh, don't apologize. Law nerds don't apologize. We just all get to be frustrated together. Look, some days in courts are like that. I want to give you a realistic perspective of what court is like. Can we go back to talking about the Boston Crusaders and the fact that their acronym is BAC? Can we just get back to that? We should get to questions. A few of you have asked how I am enjoying the Supernote. I have not had nearly enough time to play with it, but I am obsessed. For those of you that are like, Emily, what are you talking about? I have a new note-taking device. I talked about it on my tech test with the members. If you're a member, you can go watch the tech test stream. It's up there where I unboxed my new e-ink note taker. I need to figure out some ergo things for the pencil. This one seems to be working, but I like very much the, Emily, you've gone nerd. I like the nib on the Supernote pens a lot. I like the weight and shape and size of the Remarkable pen a lot. Emily, you've gone full Goldilocks. It's like, this one's not this and this one's not that. Like I need a mashup of these two because in the Remarkable, I really like being able to just turn the pen over and erase. I have thoughts. I'm going to use it more. I didn't have enough time to use it. My phone broke this weekend. I've never broken an iPhone. I have never broken an iPhone. And I go to see my kid perform in his first finals at Lucas Oil Stadium and break my fucking iPhone. I don't even remember doing it. I don't even know how. Brian's like I was touching my phone and I got like a glass splinter in my finger. And I was like, what the fuck? And I looked at my phone. I'm like, shit. That's a broken screen. And I couldn't use the screen because the screen was broken at the bottom. And so I couldn't touch it. Mess. And then the activation didn't work on the new phone. So then I was just like without a phone. But I was able to use the buttons on the phone to still record to the best of my ability. But I had like no phone. So there will be DCI behind the scenes that I will be posting as I catch up. But it was an emotional weekend, and I did not have the bandwidth to do the things. But other than a few splinters in my fingers, I was able to deal with it. It was frustrating. I was able to get some video. I was able to CT perform. I was able to talk to a number of law nerds. It was amazing to see you guys. I am just so emotional, just still kind of emotional. It was incredible. Like, I've never seen my kid perform in such a massive space. Also, super emo about the end of the season. I really enjoyed the show. Very emo that, other than recordings, I'm not going to get to see him perform this show live again. And then we had to drive home with all of his DCI gear in the car. If you know, you know, but it is it smells like a hockey bag is what it smells like. I mean, it smells like an ice hockey gear bag is exactly what it smells like. It is just on 10. On 10. On fucking 10. Whew. And my poor kid is just discombobulated. Those of you who marched, you know what that discombobulation is like. My poor kiddo is discombobulated and sick. So he is just kind of like, when is EPL? And I'm like, I know, buddy. EPL's tomorrow morning to go to school. So he has missed 7 days of school. It's going to be fine. He goes back to school tomorrow because he doesn't have a fever today, and he is going to be disoriented for a while. And he's already like, I get what everybody's been talking about. We're going to get to Q&A. I'm not going to swoop it. We'll get to questions in just a sec. We'll chat just a minute. We were driving home. Here's how picking up Travis went. I really appreciate that Cavaliers has a kind of a short offboarding, because as we were leaving Lucas Oil, there were kids from and yes, they are 21 and under. I am old enough that I call them kids. There were performers. It is not meant to be derogatory. They are just the young humans. We were walking back to our hotel from Lucas Oil, and there were other DCI performers just wheeling their bag out of the buses, out of the parking lot. And I'm like, holy shit. I can't imagine how disorienting it would be to finish performing, change out of your uniform, get scores, hug everybody, grab your bag, and walk out of the parking lot. There's no finality to that. I love that Cavaliers has an evening. They have kind of their last night after finals together. And then they have breakfast and like a short award ceremony together. And they have time to sing their core songs and really say goodbye to everybody. But then you have quite a lot of members of the core that are getting on to the bus to get to the airport. And you had kids from the international kids from Team Japan who seemed to be getting onto a bus to go to the airport to then travel home the day after finals. I can't even imagine how extensive that travel day would feel after a week of finals to then get on a plane to get back to Japan. I'm like, that would be disorienting. And then to have to use your brain to figure out where you're going seems like it would be overwhelming at best. So the international travel, I was like, they must just be in a complete fog, because we took Travis back to the hotel where we were staying. I made him get into the shower. I was like, shower immediately. Steve said 10 to 12 hour flights at least, but I don't know if you're getting a direct flight to Japan out of Indianapolis. I imagine you got at least one change of plane and are exhausted. And we're showering in a hotel, not showering in a hotel. We're showering. I mean, maybe they were able to shower at the airport, but we're showering in a high school where they were traveling out of that did not have reliable hot water, which is not really a shower after an entire summer on tour. So we took Travis back to the hotel where we were staying before we checked out and bullied him into getting into the shower. So 45 minutes later, when he got out of the shower, I was like, and now we're going to eat. And then we're going to get in the car. We ate. And then we got in the car and Travis immediately fell asleep and then has been asleep off and on since Sunday. which I definitely expected because he barely had a voice when we picked him up on Sunday and was like, my throat really hurts. I'm like, you and everybody else. He did not get sick once on tour. The second he got home, it was like, boom. And I feel for him because now it's like you have to gear back up to school. Some of the college kids at least have a few more weeks. So poor kiddo. So he's back at school tomorrow with his friends. His cat gave him no end of shit. He got back home and George yelled at him and then turned his back on him and sat down. So George is mad, but now warming back up. Fred's just like, you're here. KK said DCI is international. There are some international corps, but a lot of international performers will perform with the world-class corps in the US, and so will come out here and perform. There were performers, I know this year, from Australia, from the Netherlands, from Japan, and elsewhere. So, but there are international corps that performed at finals. There's a number of Canadian corps that performed in the international before finals for the world class. It's a whole thing. I think that was on Wednesday and Thursday. So we got Travis home. He has gotten some rest. He is starting to feel a little bit better. He didn't have a fever today, so yay, but he did not get sick on tour at all. So he did get stitches in his face, but didn't get sick. So that's how travel back from DCI has been. And then Griffin also started school. So it's been like DCI, back to school, senior year, all of the things. And then I also didn't let Travan pack his bag in the house because the turf is in all of his things. Like the little teeny pellets from the fake turf are just inside everything. They're just in everything. But I really appreciate the traditions the Cavaliers have to give the guys some time to say goodbye to one another and to give them a way to transition from that last performance to lot, to their last night together, to breakfast together, to kind of their farewell and closing remarks and their own age out ceremony, and then to say goodbye, because they get to say goodbye. But it was, if you go to finals, if you ever do not have other lot obligations, find where the Cavaliers are at. I mean, you can't miss them. All the parents stand there wearing green. You won't miss it. But the Cavaliers lot tradition is incredibly cool. So if you ever are like, I would like to see that, find the lot after finals. Their lot traditions are cool. And their core songs are beautiful. And I just cried. I'll share some of that in the Lawnard Lounge. I have some video of their core songs, and I've shared some of that on Instagram as well from others that have recorded it. So I'll share some of that. They have some all the corps have their own traditions. It's just lovely. So there was some closure, and they also are still all connected in their group. So Dan asked, how did they do at finals? I thought their run was amazing. I have some judging beef, but I have beef. I'm really, really excited for Boston. Laura said, which spoon do you use, Emily? Not the evil one. We have big spoons and small spoons. I'm a small spoon girl. We have big forks and small forks. I'm a small fork girl. If you put the big fork anywhere near me, I'm like, that is the wrong fork. That's the bad fork. I realize this is a neurospicy thing. It just is. But yes, the sensory choices are significant. Alice said, can the best solution be the appellate court when we are talking about all these discovery issues? They don't really have jurisdiction yet. So, Tony, I see you. I know. It's a really incredible special thing. And it's cool. But you can't really help your kid navigate the transition from something like a summer in core other than to just be there, because you have to experience it for yourself to really understand it. And I get that. We were on the way home and stopped at, Buc-ee's, obviously. And while I was at Buc-ee's, there was another performer everybody had their show cords on. And so there was another performer there with their show cords. And I was wearing a Cavalier shirt. Travis is wearing his cord with his show gear and his other gears and his yen and what have you. And so they kind of noticed each other. And I asked the gentleman that we saw, I'm like, what corps are you in? He's like, I'm in Mandarins. We talked a little bit about their show and parts of their show I enjoyed. He's like, I did the trumpet solo. I'm like, it was lovely. I really enjoyed your show. And we chatted a little bit. It's his third year. He was driving home himself, which again would be challenging at best, but adrenaline when you're young. So he was driving home and he took the time to give some just, again, brotherly advice to Travis about transitioning off of tour. And he could probably see that Travis's like eyes were like spinning sideways getting off of tour. And Travis was like, it's my first year. And they had a lovely conversation. It was just, it's so cool to see the camaraderie of everyone. Not all corps have that camaraderie, but it was really cool to see the camaraderie of the corps that have camaraderie. It's not transactional. And Cavaliers say often it is people over points. And you can see the other corps that treat the corps as a family versus we can find somebody to do that better than you. It was lovely to see. And it was, I think, nice to get that bit of advice and kindness from someone just outside his immediate world. And again, we got to chat about the fact that at the end of the Mandarins show, like all of the color guard takes their flags and fucking yeets them over the corps as the pillars are falling. It's just such a cool ending. But I'm a sucker. Anytime you get to hurl equipment like across the field, I'm in. So it was great. It was great. It was lovely. So we had a nice time at Buc-ee's. We saw some performers from other corps. We saw parents from other corps. We buckied. I found a new snack that I'm obsessed with and now can't find anywhere. I don't know, guys. I was at Buc-ee's. They're so good. I haven't had a Fruit Loop since I was working at Girl Scout camp and ate cereal for lunch, but so good. The jumbo Fruit Loops are so good. Emily, is this health food? No, these are road trip snacks. They were perfect. It was so good. They're jumbo. They really are. Yeah. If you guys see these at the convenience store, gas station, whatever, just pick them up. They're so good. They're just it. So, let's see. EDB, what was longer, the Buc-ee's stop or the drive back? We actually made a fairly quick Buc-ee's stop because Travis was so exhausted. And I just wanted to, like, the parent in me, I'm just like, I love Buc-ee's, but I just wanted to get him home and put him into bed and just be like, I will see you in 2 days. Which is why I made him shower before we got into the car. So I could just be like, go to bed, which was fun. I also got a new mug from Buc-ee's, which I'll share another day because their Halloween stuff is out. I'm ready. Emily, are you ready? Yeah, I'm ready. I'm ready. It's August. All of the pumpkin spice everything comes out this month. I'm ready. Also, I saw like 3 leaves fall. So I'm ready for it not to be 90 degrees. I'm ready for it. This one time at Buc-ee's, look, Buc-ee's is also its own core tradition, but Travis also lost his favorite Buc-ee's pants somewhere on tour. He lost very little for being an ADHD kiddo. So I was happy to replace the beloved Buc-ee's pants that got lost. Things were found, things were lost, friends were made. October, exactly. October, I'm ready. Oh, all the Buc-ee's Halloween stuff is out. And Buc-ee's has like a whole theme for Halloween. I won't spoil the surprise. I know. I bet you, because Starbucks is doing August 26th that like Dunkin' and everybody else will do like 3 or 4 days before. So like by August 21st, we're going to start seeing all the pumpkin spice everything everywhere. All right, let's do a few more questions. It's time. And then we're going to roll tomorrow. We're talking about Donna Adelson. Donna Adelson's get ready to go to trial. We're talking about Donna Adelson. So we will be talking about Donna Adelson. The Real Melon Lord said, I heard that lawyers like Bose speakers whilst doctors prefer Beats. I spoke to my dad about it and he told me that was just a stereotype. Real Melon Lord, we love the dad joke. Thank you. It is just a stereotype. Very funny. Hazel, good to see you, said, put it to a grand jury on the issue. The grand jury doesn't get to decide what to disclose to the state. So, unfortunately, it is up to the feds. Hearing tomorrow regarding Morrissey and company messages. I will keep an eye on it. We're going to cover, because all of Morrissey's emails are coming out. I'll go through them. All of the Adelson stuff is kind of coming to a trial. So I'm very interested. I have resisted watching the Adelson hearing, and I very much want to see. I'm ready for that case to go to trial. I think you guys are too. For those of you that are like, I don't recognize the name of the Adelson case, don't worry. You'll get caught up to speed soon enough, and you'll be like, wait, what? We'll see. I don't think this case is going to play. I think Adelson wants to testify. She's already testified at a hearing regarding her detention. I think Adelson is going to testify. That I want to see. We're just going to sit here and be like, put the bra on loop. Anna G said, could they subpoena the actual phone? No, it is gone. So there was nothing left to subpoena. I think the judge is starting to see a pattern. Music to my soul. Yeah. The judge is like, okay, so if this was done years ago, why wasn't it turned over years ago? My name is Squirrel said, is this the pickle that the Reed case was in? Not with the federal stuff, because the feds did turn it over. The Reed case has just cracked open I don't know. The federal part to every case Proctor is touching is part of it, but also the highlighting how bad the discovery process is. It is really begging for new information. Robin said, can the text still be produced from the source from former Trooper Proctor? No, it seems that is gone and that the Fed dump is what's left. Matt Thrower in the chat asked, how does the Baldwin case get dismissed for one violation of discovery? It wasn't one in Baldwin. There were quite a lot. There were a lot of issues with discovery in Baldwin too. That could have been remedied, but these cases have multiple discovery violations over years and yet nothing. The case law is very different in Massachusetts, and the way that the Brady statutes are written in Massachusetts is very different than the way they're written in New Mexico. Also in New Mexico, it was mid-trial after numerous Brady violations. And yeah. And in Massachusetts, the statute is a higher or a harder standard to meet for the defense. Swoop-de-doo said, but if the Fed investigation is over, why can't they get it? Which begs the question, doesn't it? Christy R. Travel Queen said, if the feds aren't allowing this to be shared, that makes me question even more if it's really closed. Don't disagree with you at all. Z said, ADA McLaughlin told Cannoni that Toohey, not exculpatory, but told Varner it is exculpatory to one person, Karen Reed. Isn't that perjury? I would need to go back and look at exactly what was said. Because I think as to Karen Reed, the Toohey stuff that they got includes ARCA, which is potentially exculpatory. So I would need to go back and look at exactly what was being talked about, because I don't think the Proctor texts are potentially exculpatory. They're impeachment. But I guess there's an argument that they could be potentially exculpatory because he's talking about how early in the investigation he decided it was her. But there's a clearer argument for the ARCA stuff being exculpatory because ARCA came to a different conclusion than the state's experts, which we'll talk about another day, because Morrissey was just like looking for every expert that they can find to say something different. So ARCA's clearer, but I would need the full context of both. So that's where I'm at. Nurse of interest, Jackie said EDB. We were so worried about windows opening and Karen Reed, but now we have full open gates. Keep the EDB jet running at Logan. Good. If the attention on one case unearths this much, there's a huge fucking problem. Because the Baldwin case didn't spiral into a million other cases. It was like, resolved, done, move on. This has cracked open probably what the defense bar in Massachusetts has been complaining about for quite a while. Lucky Niffler said, EDB, the way I screamed about your new white cups, I will show them to the chat real quick if we haven't looked at them. There in the Lawnard shop because we were able to restock the cups. We sold out the purple literally everywhere, like all. So we restocked these in white. We thought you guys would enjoy them. If we are ever able to restock down the road, we'll let you know. But yes, we have new white tumblers. I love these tumblers. They keep everything cold. They have stickers, so you can decorate them however you want. I have a white one here. I haven't had a chance to sticker it yet because I traveled, but I'm going to sticker it to show you guys tomorrow. Look, Emily Goldilocks, I tried so many cups, and I'm sure I drove people crazy because this is how that goes. The handle on this one's weird. I don't like the way the straw feels. I don't like the lid. The straw's too wobbly in the lid. And so when you go to drink it, it clicks weird. Like the amount of not this, not this, not this, not this, not this is incredibly difficult. This one fits in my cup holder of my car. Holds enough, but not too much. Does not get too heavy. So it does not hold so much that it is heavy on the hands, especially if you are dealing with arthritis or anything going on where too heavy of a tumbler is a problem. Also, big handle. So you can grab it with 2 fingers, not 2 fingers, all the fingers. Perfect. The lid is actually fairly thick so that it keeps things cold, easily washable. But once you sticker it, I would not machine wash it. And I would never machine wash your straws because they will bend. And then you'll be like, ew, it bends weird. So, and then it's got a rubber gasket around the straw, but really easy to clean because if it's not easy to clean, it's going to grow shit. And that's disgusting. So, and the tactile sense of the cup is not too grippy, but it's not slippery. Emily, really? Yes. It needs to feel good in the hands. So, love it, love it, love it, love it. So yes, and now we have the restock on the white one that comes with the sticker sheet because the purple one sold out so fast. We also have the I Have Questions t-shirts. They are incredibly soft. I will never be offended if you hate a crew neck and you cut them. I need to wash the one that I cut so I can show you how it will roll when you cut it. If you ever want to cut it into a V-neck, we have more sticker packs. I think I have them on my desk. Hold on. These are the stickers that come in these are the sticker packs for the tumblers. I have stickered them, but these are the sticker packs that come with the tumblers. They're incredibly vibrant. These are the sticker packs that you get on the site. So these are separate. Not that you can't use them, but if you want the tumbler stickers, they only come with the tumbler. And if you want the sticker pack to sticker your tumbler or whatever else you have, the sticker pack is there. It will show you all the different stickers. Those are the stickers. I'm in the way. Move out of the way of your shop, Emily. Those are the stickers. I love our spicy skull so much. I love the stickers. So those are the stickers. Then the I Have Questions shirt says I have questions down the back. It is a very, very soft shirt. We are restocking the fax hat. I will let you know when it gets restocked. It is not restocked yet. And then the koozies that come in 2 sizes in a 2-pack. Love them. Dr. B keeps stealing them. Dr. B's like, I love these. I'm like, I know, because then when you have a can or whatever that is starting to sweat because it is, it gets the condensation, then your hand gets all weird and wet, it doesn't drip on your desk. It's needed. It's needed. So I love it. I love it. I love it. So those are the hats. Those are the facts. We are working on restocking. It is not restocked yet. The tumblers are restocked in white, so they are there. So you guys have them. Keychains are on the list. They are on the list. 100% on the list. All right. Let me switch. Oh, I can't switch me back over. I don't know why. Hold on. It did something weird. So it is there. I will let you know in the app when the hats are restocked, and we will talk about it. All right. We will bring back the Facts Not Fuckery hat. It's going to come back in a different collection. But yes, we will bring it back. It's going to be back down the road. I cannot tell you when. So, Carrie and the Cat said, wishing T an easy post-season transition. Ending rookie year and age out year are particularly and uniquely hard. Yeah, and they had, Cavaliers this year had a number of rookouts, which would be a really surreal experience. Just wild. But yes, I imagine so. And it was the as a parent of a senior in high school where there's like lots of life transitions, seeing the life transitions of the age outs, I was just like, oh, I am not prepared. I'm just going to cry for the next year. It's going to be fine. It's going to be very fine. We're going to be all emo. Chantel said, still flying high from MCR New Jersey, now vibing with EDB. I can't wait to go see MCR. I'm really excited. Charlie, I'm so excited. Congratulations. Charlie said, just finishing my final year of law school. Congratulations, Charlie. Good to see you in the chat. Jen S. said, from Massachusetts, DCI family. Congrats, Crusaders. I know, right? Been repping my fax hat. Me too. I actually added, I don't have my fax hat on my desk. I added my Cavalier pin to it. I need to add my Neurospicy pin to the other side. I had not thought about it before, but I added my pins to it. Dizzy Bren said, love your DCI coverage. My kids are color guard diehards, rifle in particular. It's so great seeing their sport highlighted and my worlds converge. Isn't it fun? I love it. Look, I love it. I love the world of camaraderie, of band. I just love all of it. It was so incredible. It's always incredible. I love seeing them perform. Of course, I love seeing my kiddo perform. It's weird that my worlds have collided too, and that something I love is also something that he loves. And it's been fun because it's in the band space. Everybody's like, what does your kid play? I'm like, don't get a concussion is what my kid plays. That's my answer now. But I always ask people like, what section is your kiddo in? Because guard is such a huge part of band. So, I mean, the instruments are amazing. The guard makes everybody look good. Oh, for those of you saying, what is a rook out? It was their rookie year and their age out year all together. So they were doing it for the first time, but they were already aged out at 21. So they were rookies and age outs in the same year. So it's your one and done. Let's see. Extra tumbler stickers as an option. I will ask. I don't know. I will ask. The sticker pack is available, but I will ask about doing a sticker pack that maybe highlights the stickers we have in the tumbler. I will talk to the team and see what we can do. It's going to be a minute though, because they take lead time to print. Live Laugh Lorazepam said, thank you, EDB, for all you do. I have started saying sir and ma'am so frequently. Look, it works well. When you can't yell, what the fuck? It's a good replacement. It's a good replacement to what the fuck. A Desire for Civil Discourse said, is the original source data for Proctor's stuff destroyed? I think so. If not, can't they just file a subpoena and get their own copy? Not like they don't have probable cause. I think there are probably multiple problems because I don't know if the state has the PC that the feds did, and I don't think the original source is still available. New phone, iCloud wipe, and it seems like everybody's got their phone set to 30 days. So that's what it is. I am Error 404 said I'm a lurker. Well, that's always welcome. Love your videos and explanations. You make it easier to understand all the jargon. Love you. Keep up the great work. Well, thank you. I am always here for the encouragement. I'll take it. Laura M said, I just wanted to share with the law nerds that I made the honors list last semester. Future paralegal. Congratulations, Laura. Love celebrating with the law nerds. Julie O said, why is Larry Tipton in black and white or sepia? I have no idea. I don't know if it's a setting. I don't know if it's just that the light was dim. I have no idea. Let's see. Jojo said this Commonwealth is being all Gollum about it. My precious. I don't blame them when it comes to not wanting to violate the federal protective order. Meg Rose says, how happy are you to have T home? I'm happy to have him home. I missed him. And I'm also like sad for him that season is over, but happy for him that he had his season. It's a transition period, but I missed him. I'm happy to have him home. So it's fantastic. Alley Oop said, I got my official autism diagnosis last week. Thank you for supporting the NeuroSpicy Law Nerds. Alley Oop, I don't know any other way to be. Here's how I view all of the neurospiciness. It's, look, if we have high blood pressure, we need to know so we can make sure that we manage it. If we have a broken arm, we need to know so we can manage it. It's the same with how our brains work, and we don't talk enough about it. And I don't love that the DSM calls everything a disorder, because I don't think it's disorder. I think it's different ways of processing information. I think the normies call it a disorder because they're like, your brain doesn't work like mine. You're disordered. It's like, you're out of order. Not me. I process faster than you. Y'all just can't keep up. But I just wish that they would switch. I always use computer terms in processing systems. Like, I just wish we could switch to like brain processing style A, style B, style C, style D. Like, could we just, there are different processing styles. Our brains process information differently. And some of us are in groups of how we process. And then there's a lot of variation within those groupings of how we process, but there are just different processing styles. And I don't think it is this thing's typical. I just think the typical people are more focused on talking about it. The neurospicy people are off doing a million different things. It's like, wait, what? We're busy. That's boring. So we've done other things. I don't think there is a typical. I really think it is just different variations of processing. And I wish that we would get to a place where we just talk about how people process information more, because it would help. And some people process visual information differently. Some people process auditory information differently. And a lot of misunderstandings, I think, come out of people processing information differently. And if we understood each other a bit better, and if we understood how different brains operated and talked about it, it would be easier, because it's really hard to imagine somebody experiencing the world different than how you're experiencing the world. When Dr. B's like, no, I can see like 3D images in my brain. I'm like, I don't even understand what you mean by like that. What does that even mean? And some people are like, no, I see memories like a full freaking movie in my brain. I'm like, I don't understand what that's like. But then some people are like, oh no, I don't have like an inner monologue. And I'm like, how? Like, I can only understand how my brain works, because it's really hard for me to make sense of what it would be like to just have 3D images in your brain and be able to be like, yeah, okay, what? It's just all different styles of processing. Linux, Unix, Apple, Mac, partitioned Apple to Mac, or those are the same thing, partitioned Mac, Windows. I don't know. It's like we're running 3 different partitions at the same time. It's ADHD. I don't understand. Stop being boring. But my point with all of that was, when we get to other things in our physical world, we talk about them much more openly. I think all kinds of processing should be discussed as openly, because none of it's wrong. It's just how we process. And the more we understand, like, oh, I just process things this way, the less we can start beating ourselves up for not always fitting into systems that weren't made for us and that don't always work for us, and work structures that don't always work for us, and learning environments that don't always work for us. And the more we can advocate for, hey, I'm not going to beat myself up because I can't do something the way you can do it. Like, could you imagine if I'm going to use my dear friend, Amy Van Dyken, as an example. Can you imagine if I was judging myself for not being able to swim as well as Amy Van Dyken? She's a fucking Olympian badass queen. I can't swim that fast. I'm nowhere near as tall. I'm nowhere near as good. I cannot do it. But I'm not going to sit here and judge myself. I'm going to be like, yeah, I'm nowhere near that good. But like, you're amazing. But then when it comes to school, I would be like, why do people get this so much faster? Why can they do their homework so much easier? And then I would judge myself like, well, they're doing this. I should be able to do that. No, there's things I can do that they can't do. I can't judge the way my brain works against somebody else any more than I can judge my athletic ability against somebody else and feel bad about it. It's just different. That is not my skill set. I have other skill sets. But when we get into schooling environments, particularly, there's a lot of like, oh, well, everybody seems to be able to do it this way. I should be able to do it this way. No, you shouldn't. No, you shouldn't. You do things your way. You have to figure out what your way is. And the better you understand what your way is, the better you can explain it to others and go, oh, yeah, I don't work that way. Like, I don't work that way. And that's okay. I don't work that way. And it's fine. And sometimes it might be like, hey, I can't do this meeting if there's this much noise in the background, or whatever the thing is. It's not a failing if you don't do things the way other people do. I mean, have you seen the way people load their dishwasher? Some of them just do it wrong. But it's okay to say, oh, I don't do that way. And that's okay. Find the things you do excellently and figure out what works for you. And the better you figure out what works for you, which oftentimes includes a diagnosis, A, the more you can feel seen, and B, the more you can say, oh, yeah, I don't do that way. Or, I'm not interrupting because I'm being rude. I'm not trying to be rude, but the thoughts A might run away, and B, you're talking really slow. I need you to, can we speed this up? I already see where we're going. I already know what the point is. Can we just speed it up? And also being comfortable saying, can you clarify that? You're asking this, but do you mean this or do you mean that? It's okay to ask people to clarify. And that's not you being aggressive or asking too many questions. If somebody's put off by your questions, it's because they don't know how to give good answers. It's okay to ask more questions. So, law nerds, I see you. And I hear you. Heather asked, Heather, EDB noticed me on 6/15/25. You got to update it. Heather said, will you be covering the Morrissey email dump? I do not have the entirety of the emails, so probably not this week. We will see. Is there another notebook in the works? Yes, there is. Paige said, after 3 years, I finally got merch and it's so comfy. Oh, yes. Yes, we had to have conversations about bad tags. No, we can't have bad tags. We can't have bad tags. They're scratchy and we don't like them. So, yes, all of the sensory stuff. And I figure if people who don't have sensory stuff are just going to be like, ooh, this is soft. And people who do have sensory stuff are going to be like, oh my God, there's no evil tags. This is perfect. Right. So it just works for everybody. Cindy Williams said, I'm waiting for the restock on the fax hat. Can't wait. I got you. Yeah, Ohio Palm Mom. Donna testified at that hearing about the jail. It did not go well. That'll be linked down below and we'll talk about it tomorrow too. Law nerds, you are the best. I know I did not get to all the questions. I see them. I agree with you about former Trooper Proctor trying to get his job back and all of this. It's wild. We've got lots of court tomorrow. I can't believe we've been streaming 3.5 hours, but we've got court tomorrow. I'm going to be on at 11. That's the plan because we're watching from last week. Unless something goes off the rails in the morning, but I'll let you know in the app if it does. So make sure you get the Law Nerd app. And we are getting so close to having our new software up and running. You will know when we do. I cannot wait. I cannot wait. So Law Nerds, I will see you tomorrow. We will be in court with Deep Fried Potato Microphone in the Adelson case, but we've got closed captioning. We will make it work. As that case gets ready to go to trial this month, we've got some other filings in that case that I'm going to summarize, and we'll go from there. So Law Nerds, thanks for keeping me in the loop on what you want to hear about. Thanks for being here. Thanks for being a Law Nerd. Take care of yourselves. Take care of each other. Stay hydrated. And I will try not to go so far down the rabbit hole in playing with new digital devices that I get no sleep. I promise I will be more well rested. It will be fantastic. I will see you tomorrow. Bye. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android so I can keep you in the loop, because you never know when something's going to pop off. Thanks for being here, and thanks for being a Law Nerd.